it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film free therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial. Yeah, we live tonight. Take it to trial. Yeah, we live tonight. Take it to trial.
Hey, everybody. You know, I was thinking to myself today, I said, we have to find something to do in the morning because Hawaii don't start till 12 and like, we got to find us another case. Like typically we have cases like going and going, but not this week. I'm like, okay, but I don't want to get us caught up in another long trial. So, if you're on Discord, make sure you sign up and take that link. Hopefully everybody had a wonderful weekend. Yes, I'm back in here with my gangster foolery, right? With the Foolio trial. Y'all know I'm always into this. I want to be whopper with the chopper at times. So here we are. We will be going to trial soon. Yes, we will have Hawaii. Hawaii is just a hearing, just so you guys know. It just came up. I'm almost sure this hearing is in regards to that phone data, that phone dump that they had that they were arguing about on Friday, and they was like, okay, well, we'll come back in and Tuesday. The defense was going to go talk to their expert and things like that, and now we have this hearing. So yeah, we will see how that goes in regards to that. Today, I bet you that's what the hearing is about. I hope that is not going to be like a mistrial or I don't know. But the actual trial does not start until tomorrow. But we do have a hearing that we're going to set up and we're going to go into today at it says 5 o'clock Mountain Standard Time. Or Pacific time. So at that time, 5 o'clock is only 2 o'clock in Hawaii time. Okay. So let's get here. I got so many things like cooking up and so many things brewing. I am also, before I forget, we are also waiting for the decision in regards to Zachary Adams. So I'm keeping my ear to wherever I can keep it. If anybody happens to see an alert or anything going through their phone, please let me know while we on stream if that happens, so we can run that live and actually look at if they're going to show the decision, or we going to have some paperwork or somebody going to report on it. Because I definitely want to see what happens in regards to the Zachary Adams appeal. I did hear that it was probably going to come out sometime before lunch. But I don't know. Hopefully, Real Happy can find out some information for us. She was our boots on the ground that we have here at Take It to Trial that was going to be looking into that stuff. So I'm hoping that she finds something and is able to check in with us. What else we got that I need to tell you guys about or try to update you on? I think that's it for now. That as far as big things that are happening today that just kind of like came up. Let me start with my welcoming everybody in. Hey, Christine. Hello, Merelda. Hey, SD. Hey, Lynn. Hey, Just Shamrock. Let's see who else we got here. Anybody that's working and lurking or lurking and twerking, whatever you may be doing, welcome in, welcome in. I'm your girl, Sweet Pea. This is Take It to Trial, and we want everybody to take it to trial, right? So we can see what's happening in these courtrooms and what our justice system is doing. So I'm starting our stream off a little different. Yeah, I seen Lynn up there earlier. SD. Yep, she up there. So she may be working, she probably listening and working. Because she's still in her day. So I gotta show y'all something. And I want y'all to put some ones in this chat room if y'all have seen. I didn't watch this case, y'all. That's the first thing that I want to do a disclaimer on. So I did not watch this case, but I need to understand. I want y'all to point out some things for me since we are going into this Foolio trial today. And I didn't notice, and I don't think anybody in this chat told me about this. And I was like, what the heck? So I said, we got to start this stream off with this, okay? So let's get powerful. Let's not, I guess it's not powerful. Let's have us a little funny for the day. And I want y'all to connect the dots. And y'all, when y'all see it, I need y'all to let me know, because did nobody tell me? Brace yourself, brace yourself, brace yourself. Here we go, guys.
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers.
Ooh, say it with your chest.
In Tampa Bay, the state of Florida, why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence. The evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true. The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911. But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today. The evidence is going to show my son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial, witnessed me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini strikes on that video and audio that you just heard. And they added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it consecutively over and over like Allahu Akbar, which I may have said once or twice. But they wanted to make me seem like a terrorist. And so you hear it 8 or 9 times, and you hear me calling Kenyatta Barron a bitch and a whore. the evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile. The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made, because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence. The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original cause, that's what the evidence is going to show. The evidence is going to show I look alone, but I am backed by a mighty God. The evidence is going to show I love my children. And the evidence is going to prove to you that this whole entire case has been tampered with and fabricated before it's all said and done. I can guarantee you that. Mark my words. The evidence is going to show that they say, I said, come out here, son, and help me kill this bitch. But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa Brothers Gray, or any of her children, Mia Thompson, or Gracie Diggs, or Mr. Gray, heard me say any of those things. In fact, the evidence is going to show that Khalil Brown heard me say, she killed me twice, and then nothing else. The CRA is going to show, for some of you who don't know what that is, that's the criminal report affidavit that the law enforcement lead detective Thomas Sturks is the author of. The evidence will show that in that CRA, I told the neighbor, don't come outside, call 911 now. But you don't hear that on this audio for some reason. But you hear all these other things that I did not say. That same CRA will have the statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. going to show that Mr. Harmon here said that that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of shot it was, if it was a slug shot or a bird shot, where's the missing pieces of her arm? The evidence is going to show you will not see any missing pieces of her arm in that closet where she was shot. You should see some evidence of shots added to the wall to make it look like I aimed at her head. That's what the evidence is going to show. Remember, I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show that my son said my dad shot my mom. Is the correct statement if you want to cite statements, if he even said it. Because I can guarantee you the evidence is going to show you we are under the most corrupt administration you've ever seen in your life. I guarantee you I wouldn't waste your time. I would have already took a plea deal of some kind if I knew I did something like this. Because most people don't even go to trial and they know they killed somebody unjustly. The evidence is going to show you who the killers are.
The judge look like she's scared. Oh my gosh, she like, I don't want to do anything to interrupt him. I don't want to do anything to upset him. I'm gonna look at the corner of my eye.
I'm not guilty to the charges of premeditated murder, attempted murder, aggravated child abuse or battery, arson, resisting arrest without violence. And while I'm at that, the evidence is going to show that they tased me for no reason.
Oh, they tased him for no reason. Okay.
But they tampered with that video because they didn't want you to know the truth. And it might sound far-fetched.
Okay.
But I guarantee you, we're going to see who the liars are before it's all said and done. Mark my words.
Mark his words, baby.
My family, lives were taken. When my daughter was done, this is what the evidence will show. When my daughter was born, it was me who gave the command, the final command to keep her alive when she was on life support.
The final
when she was born, 2 pounds, 2 ounces, and couldn't breathe on her own. It was me who fought to keep her alive.
Oh.
But all of a sudden, I just want to take her life for no reason. I'm asserting justifiable homicide because I acted in self-defense and moved to protect myself and my children from Kenyatta Barron. I'm going to be showing with evidence several reasonable reasons to doubt the state's allegations against me. The evidence will show that the state cannot prove that I premeditatedly killed anyone because I didn't have any time to reflect or plot and plan as if everything happened suddenly and spontaneously. I responded out of pure instinct. Heat of passion.
Hand signals and this is so entertaining. Damn it.
Eliminating any kind of premeditated design. And let me just say, the evidence will show that since the state plans to kill me, if they can say that I killed my family unjustly, they plan to premeditatedly kill me.
Oh, they want to kill him. Oh, this is
cannot
DPK.
say or deny me the right to premeditatedly kill Kenyatta Barron if she killed my children. The evidence will show that Kenyatta Barron had several medications and drugs such as morphine in her system. The evidence will show she had a domestic history and was arrested for domestic violence that same year. She also was born premature, just like Trinivia.
I'm going to sustain the objection as to that particular argument regarding Ms. Barron being born prematurely. All right? You may continue on, Mr. O'Neill.
I didn't even state the basis of this objection.
I ruled, Mr. O'Neill, okay?
I understand, but I have to state the basis of my objections, right?
Well, that is correct, and I just assume what the
he's
objection is. Go ahead, state it for the record, Mr. Harmon. That's the state.
Okay. Oh, I hope he don't fight them. He gonna fight them. Oh my goodness.
Evidence will show that she threatened to kill me with a knife just a few weeks before the incident, and she was angry about my relationship with my other child's mom.
Okay, he was a cheater.
And about the fact that we had to be cordial for our newborn son.
Oh. So he just had a new baby.
That they had been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car.
Gee whiz.
Me and my son spent the whole day at my mom and dad's house working on the car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day.
The whole day. Not part of it, the whole day.
That's what the evidence will show.
That's what the evidence gonna show y'all.
Evidence will show that my daughter was prematurely born.
Okay, sir.
She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history of SLD. The evidence will also show that he was present, but does not remember accurately or consistently what happened for many reasons, making him unreliable when it comes to the actual facts. He also has been diagnosed with PTSD, as he should be, because this is a very traumatic thing that he went through. He also was diagnosed with major depression disorder, intermittent confusion, and delirium.
It might be.
The evidence is going to show, the evidence and testimony will show that Ronnie Blair, formerly known as Ronnie O'Neal IV, may have been coached on what to say by family members.
Objection to argument.
And or law enforcement.
Hold on. I will overrule the objection.
Thank you, Your Honor.
Mr. O'Neal, again, jury, this is what both sides believe the evidence is going to show. All right. And again, you will be the ultimate determiner of what the facts are. You may proceed, Mr. O'Neal.
Thank you, Your Honor. And these are also actual facts that Mr. Harmon left out when he told you about the report of his former psychologist. When he told you that he was adopted by his family members, which didn't work out as well, and he had to be placed with another family, which is now the Blair family.
What the fuck is he talking?
In that same report, it talked about how he may have been coached by family members. The evidence is going to show that my son was adopted by a detective who formerly worked in this case.
Oh, wow, that's interesting.
Whom he now lives with. And I don't have a problem with that because he needs care. But I do have a problem with Mr. Blair being involved in this case, being called as a witness, being the new father of my son, and now he's being called as a witness when he could possibly have been coached by his new father.
Objection.
Who is
Speculation
law
is
enforcement.
proper argument.
All right. And again, Mr. O'Neal, overrule the objection. Again, this is what Mr. O'Neal is asserting the facts will be. You may proceed.
Thank you, Your Honor. The evidence will show and prove that very vital evidence was definitely tampered with, which was a strategic omission to cover up the facts of this case, making much more of the evidence unreliable. As I know for a fact, it was altered as well. The evidence is going to show that the 911 call of Kenyatta Barron is not compatible with what Khalil Brown saw and heard outside of my home. The evidence is going to show, when it's all said and done, who put those excessive lacerations on Kenyatta Barron's face. I can guarantee you that. In this trial or the next one, I can guarantee you that.
Oh, guarantee. Put a stamp on it, baby.
Like I said, I look alone, but I'm backed by a mighty God.
The mighty God. Oh, boy. You see, look alone. Tell him.
And ultimately, it will show that none of the state's witnesses can draw any conclusion, especially because they didn't see anything that refutes my self-defense claim and theory. And nor can the state do so beyond their very reasonable doubts that will be revealed. The very reasonable doubts that will be revealed by me. And that's all I have to say.
That's all you got to say. Oh, So I wait a minute. So let me see exactly. Okay. First off, I don't even know his name. I've never seen the trial. Wait a minute. Let me get it up here so I can tell y'all what his name is, because I didn't watch this trial. Ronnie O'Neal. I didn't watch this case, but when I was researching and getting our stream together for our Foolio case, and I had put something in about Judge Cisco, and his thing came up, and as soon as it came up, he started yelling. And I'm like, oh, she always getting all the action in her courtroom. I said this case probably would have drove her right up a wall. Y'all want to watch this trial? Oh my goodness. This guy, like, his energy alone, I was like, with that, like, this hair, good grief, what is going on with this head? Oh goodness. So y'all tell me. I know that we looking at some stuff for some trials, but if y'all want to watch this one, we can watch it. But I just wanted to kind of I was like, Judge Cisco, no wonder she on there like at the Foolio trial, like, and she doing all these DP cases. This case would have sent me cuckoo for Cocoa Puffs. I said, well, I feel bad for the judge because he looks scary. He looks scary as hell to me. And she get all these scary people that's in her courtroom. But with that being said, y'all know the last 4 defendants, we have been covering the hearings that they are having in regards to what evidence is going to come in, what evidence is not going to come in. And this is the Judge Cisco, okay? You know, it's in Judge Cisco's courtroom. We seen her for the Alicia Andrews case. So I was just kind of like, I would love to see how she handles him, because he looked like he'd jump over the bench and whoop on her. I'm just saying. So in regards to our coverage on the Foolio case, we are going to get into the hearings. They are still filing motions. I woke up this morning and there is additional motions to be filed. I have no clue, Lynn. I just seen, I didn't watch any of it. All I heard was I seen her face and I heard him yelling, and I was like, oh, I gotta show this to the chat. I don't even know who's seen it. I'm like, I don't even know who's seen this case. I have not seen it. So, like, if y'all want to watch it, I'm more than welcome. We can watch it in the morning. I mean, you know, we can watch it this week for our morning, because the only thing that I know other than that is when we have our Hawaii trial in the afternoon. But I would love to do some things with you guys in the morning. And the reason why I brought this case, because we got so many pre-trials and there's so many important things that's coming out of this case for the Foolio trial that we need to kind of cover so we can be okay when it's time for us, because that case does go to trial this month. So, yeah, and I just happened to see Judge Cisco on there. I'm like, dang, I wonder how she handled him. This man over here yelling. I don't know what he yelling about, for fuck's sake. Like, oh my gosh, like he scared me when it first came through my headphones. I was like, what? Who yelling like that? Even Daryl Brooks didn't do that. He did. I don't think he, I don't know. I don't remember him yelling. I just remember him being like, oh, maybe so. I guess maybe he did yell. I don't know. But this guy was talking to the jury. I don't know. Let me see if I can find it out. Let me see if I can look it up for you, Lynn. It looked like, I'm telling you, in Florida is not playing with these people. If you in Florida, this is a wake-up call to y'all. They have the DP in every case where somebody is where you can get the DP, baby. They giving it out. They handing DP out like yesterday's news. And you know, with the Foolio trial, these people, they seeking a DP for them too. They're not playing with them. So if you in Florida, I think you should have several seats. You shouldn't be doing nowhere. But so Lynn, he is charged with 2 counts of first degree unaliving, and then 1 count of attempted first degree unaliving. He got aggravated child abuse, arson, resisting a law enforcement officer, and yeah. So he got a long list of charges. Yeah, Daryl Brooks complained a lot, pretty. And you know what I noticed from this guy, just from his opening statements, y'all see the prosecutor tried to object. He knew what to ask. So it don't sound like he's stupid about representing himself. And that, I find that interesting too. Even, I don't know how he goes in the rest of the trial, but just seeing that little exchange where he was like, well, you know, if I object, I have to say what my objection is for the record. And the judge was like, you're absolutely right. And she made the prosecutor actually state what his objection was about. So even though she still sustained it, he made a good call. And then when the prosecutor objected to something else, she overruled it. So yeah, very interesting stuff. So it seemed like, and I think with Daryl Brooks, the problem was with him, he was going back there and talking to his homie in a jail cell. And he was like, okay, you know, yesterday in court, homie, you know, you wasn't doing so well. So when you go back in there tomorrow, this is what you're going to need to bring up. Just keep yelling grounds all day and let's go from there. So it looked like this guy actually, like, at least from this part. Now, I don't know in the rest of the trial. I'll put a survey up there if you guys want to try to, if y'all want to watch that trial. Like I said, I have not seen it. So it's all fresh and new to me, because I was like, what? I wonder how many people saw this. Oh, SD say this was the best case ever. And we know Shabiz is your girl. SD always want to watch some Shabiz. She likes to see her act out. Okay, so with that being said, I am going to get us into our case, that our trial, our coverage for today. With our Foolio trial. Thanks for just listening to that. I will put a survey in there in our chat. If y'all want to watch that trial, I'll be more than happy to set it up for us to watch it. I just thought that would be a funny way for us to end, you know, be entertained today with his shenanigans. Okay, so today what we are going to be watching is the hearing where the lawyers for the 4 people that are left in the Foolio trial, they're hearing in regards to rap videos and some gang act ties to be ruled out. The 4 people that we have on trial, we got Thing 1, which we have named. We have Thing 2. Don't ask me what their names are, because they some Murphy boys, and I just named them Thing 1 and Thing 2 because their hair is scary. They scare the crap out of me just by their hair. Yeah, and I was told that my thing is wrong, so don't pay attention to my little thing because I heard it's wrong. But so we just named them Thing 1 and Thing 2. And then we got Isaiah Chance and we got Sean Gaffright. Alicia Andrews, we know she was tried in the same courtroom with the same judge, but there have been some updates with her case where Judge Cisco was thrown off the case, and that's why we have not went to sentencing for Alicia Andrews. And quiet as kept, guys, she has a new, her last motion was with her new judge, and it's being, I think it's still in review. I haven't heard anything update in regards to it. I think her next date for her case is like later in April. But she asking the courts to throw her whole conviction out or give her a new trial. And so we'll touch on Alicia stuff when it get closer to her coming back into court. But I know these guys are going to be in court the 31st. Let me see, because they send me alerts. So we got a hearing on this case tomorrow on the 31st, and then we also have one April 9th. I believe courts, I think the jury selection starts like within the next week or 2. And then we got another hearing on April 8th. So like we getting down to the nitty gritty of this for trial to start. But let's go ahead and get into our coverage today and see what they are arguing. And then I do have the actual paperwork and documentation for the rulings. So we'll see exactly how she rules on some of the stuff that she won't rule on right here. Okay, guys, so let's get into it. Remember, I am checking all sources that I can for Zachary Adams to see if he will get an appeal and get a new case. Please, guys, if you see any alerts or anything, just let me know. Here or Discord, however you can reach me, so I can make sure I bring that coverage live. I am also looking forward to. Hey, Eleonora. Yes, yeah, I'm looking. I'm staying on track with that. And then we will go into Hawaii at 5 o'clock Pacific Standard Time. Okay, here we go, guys.
Okay, so some housekeeping matters first. Let's see. All right. I know that when we were here on Tuesday that Mr. Gathright had some motions that I think I ruled on, but I couldn't locate the physical copies. So I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon. All right.
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I mean, I think it might make the most sense to kind of proffer it and address it with the expert.
Okay. Well, I do have that one. So there were 3 motions that I located in my stack of pleadings. And I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied. And I think that was the CCP aggravator, which I denied. So that has been denied. Do you need it?
I'll just check it just to make sure I got it.
Okay.
I think I got it.
Okay, I think you do too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied. And that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures. And there were paragraphs. I think A was granted, B was granted, and C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So, Madam Clerk, that was granted in part, denied in part, as articulated. And, okay, so I think those are the 3 motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members. And specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845 2nd 74. I did take a look at that opinion. And in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away. He adopted her 4 children and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo, he argued that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right?
I will
So-
pass it on to Mr. Hernandez, Judge.
Yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case, obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life. Okay? So, all right, very good. All right, so let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
Your Honor, my position in the motion, and I know the state's early disputes this, is that this firearms identification evidence is not product of reliable principles and methods and should not be.
I'm sorry, excuse me.
Should I-
Yes.
I can't hear you there.
This is better than courtroom 1, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So unless Your Honor is inclined to agree with me, I think that what Ms. Norton and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right, very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies just for appellate purposes.
Thank you.
Okay, so just remind me that we need to do that before the firearms expert testifies. All right. So I'm going to grant the motion to strike. All right.
Judge, one more housekeeping matter.
Sure.
Judge, I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum, I realized that very early this morning, immediately contact Ms. Ismer, and this morning at about 8:30 or maybe before, I filed it amended. Now, I will tell the court that the amended is in fact very similar to the supplemental.
Okay.
There's not anything of grave change to it, but I wanted the court to be aware that that was my mistake, and I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not require testimony and probably very brief argument.
Okay, that's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that been scheduled yet?
I was gonna talk about that today. I know
Okay.
because of the voluminous nature of it, I wasn't even sure the state was ready to do that.
We do have to, we've gotten some items out of evidence, but I think there are some additional physical items that we need to get out of evidence that were put in trial.
Right.
So we will get that done. I think the photos for the most part, we're just gonna reprint. But they are a lot of photos, so I do need some time, but we will schedule that.
Okay, so on the lunch break today, I need you guys to figure out a prospective date for that, and then I will set a motion hearing date after that. But we need to have at least an idea of when that's going to be, because I know your calendars are busy, and I don't want you all to get jammed up, and then we can't get together at least one last time to go over any and all outstanding motions or issues.
Yes.
Okay. All right, and I know we discussed this on the state's motion in limine regarding victims, gang activity, and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us today, by today.
Okay,
And Judge, that would be any videos that we intended to enter.
correct.
Any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
Okay. All right, and so state, you're going to take a look at those and then let me know if you have an objection.
Yes, Judge, I believe the attorney for Mr. Chance provided us with a list of videos.
I
So
did
we will
see-
let-
Yeah, I did see that. Okay, so I'm going to actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so, whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes, Mr. Wise.
While we're talking housekeeping matters, there is, at some point today, I'd like to briefly readdress a question Your Honor asked during my traffic stop motion after having done a little research on it.
Sure,
I can do that now.
sure.
Okay. So when we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car
that Mr. Gathard was in would give a basis for, I guess, arrest. I don't know if it was arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons. But having done a little more research, I don't see a basis. I don't see a reason why his possession of a firearm, being under 21 and over 18, was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful. But I don't believe possessing a handgun between 18 and 21 is unlawful.
Okay, state what's your argument.
Judge, even, Judge, it is securely encased. I think that he is correct, but there is a law for that. But what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made. I think law enforcement took the position that was also.
They did, Judge. They believed that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, it's our understanding that that was in the console of the car.
So do you agree that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay. All right. Thank you. Okay. All right. So next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's going to come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's going to argue that motion for the state?
May I be heard, Judge?
Yeah.
Maybe, Your Honor, and again, strictly up to the court, having the defense argue their motions as it relates to limine of all of those things might subsume the state's actual motion when they argue against the same.
Well, no, and I agree. I agree. Really, the point of the hearing the state first is for the state to articulate exactly what it is that they're intending to admit. So that's my motivation in asking the state at this point to proceed. It's for them to identify on the record exactly which incidents they are intending to introduce, and then I will have the defendants argue their various motions.
Thank you, Your Honor.
Okay?
Judge, have one moment.
Sure. So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge, I have so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Cousteau Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. The shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. On the same day that Tilley was murdered, immediately after, there was an attempted murder committed against the victim, in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you were seeking to introduce?
Yes, Your Honor. That's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all of the defendants. First of all, the 3 defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members. And as part of our requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again cite to that Richardson case what was very clear, that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred again up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive. And the court acknowledged that that was highly prejudicial, especially the prior shootings, but it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case. That historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that that background, even the collateral crime evidence of the prior shootings, was not outweighed, that prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start. Joe Rod Adams, I apologize, starting with that one. In 2018, he had the nickname Spaz, was a gang 1200 associate, and is related to the Murphy. So obviously going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm going to rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion. All right, because then once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is going to come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
Okay?
I may ask for the assistance of Ms. Ismer. She is kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so yeah, so what I'm trying to say is that the any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's going to be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in. Okay? Okay, very good. All right, anything further before I turn it over to the defense, just with regards to the 6 previous incidents?
And okay, and Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there's several paragraphs that list different items, and so at some point when we go through those items, I would like the opportunity to address those items.
Sure,
Okay,
absolutely. And one question. There was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy, and cousin to Davion. I now believe that is the reverse. Is that correct, Mrs. Smith?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is.
So I was going to ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me. Well, it'd be Mr. Gonzalez and then also Mr. Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay. Same, Mr. Sonardi.
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay. So what's your proof?
Statements are calling Mr. Joe Rod Adams.
Whose statements?
Mr. Murphy and Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother.
And was that in text messages or
In their interviews.
in their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detectives' evidence as far as following the gangs that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Very good. Okay. So who wants to go first?
I'll go, Your Honor.
All right.
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Daubert challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens, if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be 3 detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of, by opinion testimony of rap videos, evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence. The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
And I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay.
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance, and there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement, any other than an individual grudge or a particular issue between one person and another that doesn't trickle down to any type of group gang type decision or plan. And that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly, Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit. And at that particular time, he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDTA, H-I-D-T-A. And these are 3-day organizational crime conferences where general gang intelligence is discussed. And they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition. And that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis, community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are. And certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to
Correct, not as a gang expert.
Correct.
He's a fact witness.
Yes, sir. As it relates to Detective Griffith, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDTA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited. And he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document. He can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge And that's after a long standing history with the department itself. But a gang in 2022, January, and he became assigned to 6 Block. He also went through the HIDA training. He also went through and did a couple of other trainings of general types, and talks about how social media, downloads, rap videos, interaction, again, with community members would be his source of information, again, with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also had some, he was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. It doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, 3 witnesses, Detective Leader, Griffin, and McCullough. They each are specialized in a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
Correct, Judge. And we
y'all need to see that verdict for the antifreeze trial? I know we didn't cover it, but y'all can put a 1 in the chat if y'all want me to go over there and watch the verdict. If y'all need to see, if y'all want to see the verdict live, I don't have a problem with showing it. I know we didn't cover it, so I have no clue anything. I know they've been out deliberating for a long time, what I would think is a long time, but hey, Jody. Yep, they surely do. They surely do. Okay, let's see here. I will so we'll show the verdict real quick in the antifreeze trial. For those that were following it or did catch some glimpses of it, and then we'll go back into what we got going on in our Foolio trial, our Foolio pretrial hearings. Wait a minute. Okay, so here is the verdict, just really, really quick.
Let's set a sentencing date. I suggest later this week, Wednesday.
Oh, we
will
must
work
have
well
missed
for
it.
me.
She must be guilty because they saying sentencing. Sheesh.
Now back in session, you may be seated.
Your Honor, we are back on the record in the Judy Church matter, and the jury has a verdict.
So we've been informed the jury has a verdict. They're lining up. They're coming into the courtroom in just a moment. I just want to make sure that everyone in attendance understands that there's to be no reaction to the verdict, whatever it may be. I expect everybody to remain composed and stoic, and I expect everyone's best effort in that regard. With that, we can bring the jury.
All right, for the judge.
Judge and the defendant remain standing. All others be seated.
Mr. Foreperson, has your jury agreed upon a verdict?
Yes.
May the court have the papers, please?
Thank you. The verdict is in order, and you may inquire.
Mr. Foreperson, what say you to indictment 2377 CR 14001, charging the defendant Judy Church with murder in the first degree? Is the defendant guilty or not guilty? And if guilty, guilty of what and on what theory?
Guilty, offense as charged, deliberate and premeditation, and extreme atrocity and cruelty.
Mr. Foreperson and ladies and gentlemen of the jury, hearken to your verdict as the court has recorded it. You, upon your oath, do say that the defendant, Judy Church, is guilty of murder in the first degree on the theories of deliberate premeditation and extreme atrocity and cruelty on indictment 2377 CR 14001. So say you, Mr. Foreperson?
Yes.
So say you, all members of the jury?
Yes.
Would you like the jury to be polled, counsel?
Yes.
So say you, juror in seat number 1? Yes. So say you, oh, I'm sorry, juror in seat number, it's okay, sorry, juror in seat number 1. So say you,
Yes.
juror in seat number 2?
Yes.
So say you, juror in seat number 3?
Yes.
So say you, juror in seat number 5?
Yes.
So say you, juror in seat number 7?
Yes.
So say you, juror in seat number 8?
Yes.
So say you, juror in seat number 9?
Yes.
So say you, juror in seat number 10?
Yes.
So say you, juror in seat number 11?
Yes.
So say you, juror in seat number 12?
Yes.
So say you, juror in seat number 14?
Yes.
And so say you, juror in seat number 16?
Yes.
Your Honor, may the verdict be recorded.
It may.
Thank you.
Please be seated, jurors. Please be seated. Everyone else. Jurors, I make no comment upon your verdict, as I've told you over and over again.
Okay, so there's the verdict for that one. She's guilty. It looks like she's going to be sentenced. Another one bites the dust, is all I can say. I'm surprised it took the jury that long, but I do want to keep us into what we're doing, but I wanted to bring that to you guys. So let's go back into the discussions in regards to the Foolio trial. And then the ones that she did not make a decision on today, I do have some of the decisions up, so I'll provide those to you guys. That we have so far. And like I said, they do have a hearing tomorrow. There are motion and limines that have been filed as of early this morning. Yeah, the defense is fighting really hard for certain things, but we'll get into those afterwards. And I will, for those that are on our Discord, I will make a link for the Foolio trial, and I will drop all the documents in there for those that want to read it word for word. I'll drop them in there for you guys. Okay, let's go back into our case. Which trial starts Monday, Stacy? You have to put the trial name in there for me. I don't know which trial you're talking about. And I would love to know. Like, I'm trying to figure out this stuff. Not figure it out, but I haven't seen anything like really coming up. But yeah, put it in the chat if you can.
It will not be cumulative. There may be 1 or 2 that we cover it all with 1 or 2 and not call the third, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. We'll cross that bridge when we get there. So,
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang. So there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria are unknown interviews with unknown people.
Sure. So, but there's two separate issues here, right? Okay. So what we're discussing right now is the historical
Agreed.
evidence. That's
Agreed.
all we're
I just
discussing.
wanted to respond to.
Yeah, no, that's fine. And that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's going to be permitted to come in? And three of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're going to call to establish that. Okay. So I just want to make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's going to come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine, in which he's challenging the expertise. So
We are.
We are, and we'll get there.
Okay.
We'll get
All right.
there, but I'm going to first deal with the issue of the admissibility of the history of the gangs in Jacksonville.
Yes,
Okay?
Judge. So in my motion, and I'm not going to go into it because I want to get to other things, I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this
Yes.
motion
Okay,
for
that's fine. So,
admissibility.
because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce. So,
And I'm going to just touch on each one of those,
Okay.
only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there. So
Okay,
I will
very good.
touch on those very briefly because they are in much more specificity and particularity in the motion, but I'm not going to just track the motion. I'm just going to try to give
Sure.
some bullet points on each one of those
okay,
circumstances.
thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang. And therein lies, even at its root, a problem with what they would like to testify to as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The states can introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion. But regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just again to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that
Yes,
case.
he was, and will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an emotion limit on that. And I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay, well,
and about gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I believe he will testify under oath that
Right.
in fact that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. And now what other contextual knowledge he may have about anybody here or gangs in general.
No, I
that's
know,
another
I know.
story.
I'm just trying to draw the distinction between at least that incident. The state will have some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibby Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, and that was from February of 2019.
Yes, Judge.
Okay, then we move on to August 16th of 2023.
Yes, that's Jake Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones attempted murder. That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's going to be able to testify to, right? Other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say. But when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that murder occurred. You might even be lauding that murder occurred or that shooting occurred. And certainly the state would like you to take the leap or allow a jury to hear or allow somebody to testify to. That's an admission of committing a crime. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but they would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So what's happening in these social media posts and sometimes in these rap videos are the same thing that's happening at the same time out in the community. Somebody gets killed. There are thousands of people talking about it. People hate it. People like it. People laud it. People think it was deserved. People think people know what happened. So-and-so got shot. So-and-so was walking down the street. This is a community whereby social media, the ability to have knowledge and information is quick. And detectives testify to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful. I believe the court has to be careful not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
Judge, talking specifically about the 6 instances, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl. And it escalated. And at one point in time, Mr. Howard, a state witness, told a person, somebody's going to die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Biddy Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None, law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was in fact had some close relationship. They even whether or not they were actual family members, maybe refer to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge. I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another,
Right.
that would provide the modus
Well, let me ask
to
you
kill
this,
somebody 6 years later.
and remind me, and I may be because I may be misremembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the gravesite of someone's being desecrated? Am I remembering that correctly?
You are, Judge, it's another incident though, that's the town center shooting, but
Okay.
there are references. I'll let
Yes, Your Honor, that is correct. And it is of Mr. Joe Rod Adams.
Right.
Great.
Right. So Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something.
Yeah.
For the scene.
Yeah, I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Biddy Gaynor, February 15th, 2019, 5.5 years prior to this murder, essentially Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jailhouse snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened or why it happened or under what circumstances it happened. I think that Detective Drabeck in his deposition stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Biddy Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives, Queso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams and killing the other person suspected to have been involved. So the 2 6 block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next briefly is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives again. And I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to it.
Can't gang experts testify to that?
No, Judge, I don't believe they can.
Okay.
Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity. I don't believe there's any indication that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testified to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilly had something to do with Sedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Foolio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is, in fact, potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
Which is NIBIN matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilly. And he believes that Isaiah Chance was involved. And his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and,
the state's not going to be able to get into that.
well,
It's unsolved, and Detective Nieder is not going to be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been suggested up to now. And
No.
am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting physical evidence that ties him to that,
Yeah.
as well as any statements he made from other, but not through the opinion of
Right.
the officer. They have not charged it.
Not relevant to Mr. Murphy and not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental,
Well, that's a separate issue. So
right,
let's just
supplemental
stay
issue.
focused.
Yeah, Judge,
So listen, no gang, the state calls a gang expert, whoever it may be. They're not going to be able to opine about culpability of anybody who hasn't actually been charged or arrested or proven guilty. So that's not going to happen.
Okay, because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand. Law
Okay.
enforcement says lots of things in depositions that never come before a jury.
Understood. That's why we want to make sure that that's
Yeah,
covered in
it's
a motion
not.
like this. Judge, in an incident by incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore, let's take these 6. We believe that it establishes that the state doesn't possess witnesses with firsthand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups. Part of the reason being that they're hybrid groups and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure. And I indicated in my email yesterday that you all would be given 20 minutes each. So I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're
sure
not, Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in. So I'm going to give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to
The admissibility.
yes, Judge, which is part of this, a large part of this, the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
Correct.
They were tried together, but with separate juries, notably. And essentially,
Because of a Bruton problem.
Judge, there's no Bruton problem here. There's no antagonistic.
No, I know, not in
here.
our case. In Richardson Hayes, there was a Bruton problem, which is why they had 2 separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these 2 gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7th 3rd 11/23. In that case, the specific time frame, as far as the historical gang evidence that was admitted, was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence from which kicked off in 2023. Like you had the two incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet. And then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that there's some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
fact evidence as to his involvement in that murder.
Right.
Judge, the big difference here is that in Hayes and Richardson, firsthand knowledge, there were multiple witnesses that testified that the defendants were members of gangs. They were members of the same gangs. They interacted with the defendants, in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified to they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
They-
Judge.
yeah.
Which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay,
I-
so I'll hear from the state on why gang experts can testify to that.
And so, Judge, I could, if you court's read the opinion, you're not going to give me much more time. You're blaring at me. I get it.
I'm not, for the record, that's not a glare,
I-
Mr. Gonzalez.
I didn't want the record to
That is
reflect that.
It's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those two cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, that's what the state needs. They need a firsthand witness to corroborate. They corroborate the videos that were admitted, the witnesses, the firsthand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree. It's a separate issue. So
Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detectives, in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skip through that part, but it's in the motion, and what somebody thinks something says without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on the arguments that I've made and also those that are in the motion. I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible. And especially to show that there's a motive for these killings, it should be done with competent, non-hearsay evidence. And those prior acts are rendered irrelevant when they're not done that way.
okay, very good. Okay, let's see, Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted Mr. Gonzalez's?
Correct. As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost to January 2023.
Do you mean 2016? You said 1916.
I apologize.
2016.
2016 until January 2023. The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated the 5 years window under the statute that expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy would be so highly prejudicial as to not to overcome its probative value. We would ask the court, as to Davion Murphy, to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess before I begin, maybe for point of clarification, there, as you've heard, casings found in Mr. Gathwright's home that not even matches to 2 prior incidents. I think the only one that's of the 6 we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state is. It sounds like the state may not be seeking to admit evidence regarding these other 2 alleged incidents. One of which I don't think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the NIDA correlations to the other shootings from the traffic stop as well as from the safe of Mr. Gathwright's house, we are not going into. The only ones that we are going into were the ones that were actually confirmed, and not just NIDA, but FDLE matches.
For Mr. Jones.
Correct.
Okay.
The attempted murder and then to our case here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he's a gang member. As you heard from all the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathwright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathwright and Chance, but I believe there's some thought that they must have been best friends. And I don't even think there's evidence to support that. The only thing connecting Mr. Gathwright to these gangs is his communication with Chance. And quite frankly, I think the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member. I don't believe he can even really qualify as a gang associate just based on the fact that he's communicating with Chance. But that.
Well, the state hasn't not identified.
No.
And then, as far as I can tell, they're not seeking to prove that Mr. Gathwright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
We're not approving an enhancement against him, but he certainly qualifies as an associate by the statute with his association with Isaiah Chance. And we believe it's the jury's decision to ultimately find who is the associate and who is a member.
Okay. All right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities, the only connection, again, to Mr. Gathwright is the fact that he's communicating with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathwright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilley. The only connection, again, with the Charles Jones incident that takes place on the same day is the casings that are found in the NIDA matches. But as you heard from the detectives last week, Mr. Gathwright was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one, as Mr. Gathwright, could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite 2 cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have referenced them with regards to the severance issue too, but it's Thomas and Gilly. And it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. Maybe they were even connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants are being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place. And it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed. And it appears, based on my reading of those two cases, it may have been for that reason. But all this prior evidence comes in both cases, it becomes a feature, and in both cases, the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good. Thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Murphy as we would all other defendants' arguments.
Sure.
Same here on behalf of David and Murphy.
All right, very good. Ms. Petratus.
We filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise in their arguments, and I'll try not to be too repetitive.
Okay, and this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And just to go over the murders again very briefly, we have one from 6 years ago, the Spaz shooting, which is a alleged 1200, not ATK, which Mr. Chance is reportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. That is alleged, well, it's not alleged, it's a charge of ATK. The next 4 that all occur in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved. Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime that we don't have conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't. It's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They're not confessing to crimes for him. It's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1200. The Beale shooting is alleged to involve 1200, not ATK. And as Mr. Gonzalez stated, the last Charles Jones shooting does not involve a gang at all. They're going to say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said it's a continuation and consequence of preceding events. And I'm going to argue that 6 years and 5 years ago, there's not preceding events to this crime. I would argue even, we have an 8-month gap between the last event in this historical gang war and this shooting. The court mentioned Griffin in the Richardson case. It said to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes In the Richardson case, again, 76 days. That happened one after another in a 2.5-month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to give the state why these victims were in fact the victims. We had a toddler and we had 2 elderly, or maybe not 2, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. That's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings. And I think that's what the court should require. one other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm going to use witnesses in quotes, come in here and testify to show the other murders 6 times. That's days. It's
Well,
days
yes,
of testimony.
no, and I do just have a little experience because of Andrew's case. That's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case. So.
Well, we're talking, and I understand that, but I think that's going to be different in this case because I think they're going to try to bring in more.
Well, we'll see. You're right. It cannot become a feature of the trial.
And I find, I understand, but I just find it hard to believe it will not end up being a feature of the trial. We're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but everything else that I would get to is either in my motion or has been stated by the co-counsel. So that's all I have.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce
Judge,
into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And who's that going to be? Do you know?
Judge, we believe it's going to be Detective Nieder. The other 2 are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds
Sure,
to...
that's a separate issue.
That's a separate issue.
In the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying like this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not going to be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was, and then the gang expert is later going to connect up that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen, and the victim of one gang is killed, and then the next day a victim of the opposite opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes, the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case. And some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also goes to our gang experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media. And it's not hearsay. They are visually monitoring it and they see a death happen. And then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed. All of that.
Desecrating someone's gravesite is pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth. And the jury needs to have an accurate view. And some of this is highly prejudicial towards the victim because the victim is out there doing the same thing, which makes him a target. And he is dishing and disrespecting the close members, people that we can connect to them, either through their wearing necklaces. They have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not going to call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed and his name. And then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed. And the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder. And we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant. They're inextricably intertwined, and those specific cases are tied to our victim and the defendants in this case as being relevant, and again highlight the animosity between these 2 groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members, was shot. And so that is the state's argument, that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive to kill Charles Jones, the victim in this case.
Okay, so in the Hayes case, the court stated as follows, and get the page number, at page 1130 of that opinion. In establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the 6 identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity. Okay, so those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm going to take a recess.
Wow.
And so actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm going to grant it. Let me just take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list, as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule. Okay. All right. So as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied. However, defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied. However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other 2 instances, the state is not seeking to evict, so could that be?
Yes, it's denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted to any other incidents that are not part of the 6, and that goes as to all defendants. Okay, so we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay. All right, we'll take a break and I'll be back at 10:50.
So of course I'm gonna pull us back. Pull us past this break, but as you can hear, that they talking about the videos in regards to, they ruled on the she ruled on the motion in regards to the videos, and I guess they're gonna take them step by step, and she's allowing for them to come in because they're kind of intertwined. But what I noticed today is that with Isaiah Chance, and y'all heard her kind of saying that at the end. Let me just show y'all, because they are fighting really hard. I guess the lawyer just doing what he can do, right? They gotta do whatever they can. And then I'll take us back into the hearing. So here you can see right here, it has it was dated this morning, actually. So it's a motion in limine that's filed for Isaiah Chance again. So now he's asking to block this evidence in regards to a video. The defense wants to exclude a music video called "Blood on My Pradas." I don't know what song. I haven't seen it, but okay, I have to look at it. I can't play it on YouTube. I will play it on the ones and the twos for y'all. Specifically, they want to block the video itself, any screenshots, steals from it, any mention of it in the testimony or argument. Now, what they're saying is that the video has no direct connection to the murder of Charles Jones. It includes imagery, like images like firearms, dead bodies. I don't know what kind of video this is, but they saying it would be too prejudicial and it would inflame the jury, not actually prove anything. So I'm assuming this is Chance's, maybe this is his video. Oh, it's by Isaiah Chance, right? It has it on here. So "Blood of My Prada" by Isaiah Chance. I don't know what kind of video it is, but so, and I think the big moving strategy for the defense is they don't want the jury to see this with blood on his Prada and guns and dead bodies and all of that stuff. That would probably be very prejudicial. So the defense is trying to control the narrative, keep the case focused on the actual evidence of what happened to Foolio. But I expect that the prosecutors are going to push back, of course, and they're going to say that this shows the mindset of Isaiah Chance, is relevant to who he is, and possibly try to link the lyrics with any images from the case. So that's just to kind of give you an update in regards to that part that she did rule on. Now, let me see. I think it's another one that I have. Okay. For anybody that is, let me pull this up so we can go ahead and review over this really quick. And then we'll go back into the hearing, guys. And like I said, anybody that's on our Discord, I'll drop the link in Discord. But if you are on Discord, I will drop all these documents in our Discord up under the Foolio tab for anybody that is into reading documents. Okay. So right here is the, what I have pulled up right now is actually the order. And this is basically the order that the judge is, the judge denied the motion to sever. So at the last portion that we listened to for this case, remember the judge was telling the prosecution team, look, either y'all can decide that y'all want these text messages in, and I'll explain to you the text messages. I'll remind you guys what text messages they are. It's a text message from Isaiah Chance to Alicia Andrews. It was around October the 8th, 2023, telling her to stay low and stay loyal. The second text was a text from Davion Murphy to Sean Gaffright on June 23rd, 2024, saying, essentially, I'm coming home. My thirst is quenched. pop a bottle of that Don Julio today. Y'all know what that means. You know, they drinking on Julio Foolio, you know, and for some reason they wanted to smoke on people. But the judge told them, hey, if y'all really have to have these text messages in talking to the prosecution team, then we may have to either have 2 juries or we may have to sever some of these cases. And so she allowed them to go back and kind of figure out what they wanted to do. Now, of course, the state wanted to get this evidence in, but it would be unfairly prejudiced to others in the case. So the judge, you know, definitely told them that they had to think about it and find out. They must have came back and told the judge, hey, look, we don't want separate juries. The text messages is not that deep to us. We're just not going to use the text messages. So the judge specifically noted that on the June 23rd text was sent after the homicide, so it was not admissible as a co-conspirator statement because the alleged object of the conspiracy had already been completed. But the key part of this is that the state told the court it would not try to introduce this stuff, so it won't happen into the case. So the judge denied. You can see the date. That was March the 26th, 2026. She has denied the order, you know, in regards to severing these cases. So they are going to be tried together. So I guess unless there's something else that comes up during these hearings for pretrial that makes it where they need to be separated, they are going to be tried together. So the severance is denied. There are no separate juries. The 2 text messages that I just read to you, they will not come in. The state is not going to use them. So that cleared the way for them to have a joint trial. In regards to, I see a question from you, Derek. Alicia Andrews has not been sentenced yet. Remember, the judge was kicked off of Alicia Andrews' case, and she has been assigned to a new judge. And since she has been assigned to a new judge, her sentencing has been pushed back because they are the new judge is getting herself familiar with the case, but her legal team has filed motions in order to actually throw all that shit out. They said throw it all out. They said the judge is bad, throw the whole case out. So she either wants a new trial or she want it all thrown out. No, she didn't get sentenced yet, SD. Okay. Here we go. So I am going to go ahead and we're going to go back into our hearing, and any other things that she talks about that she has made a decision on, I'll bring to you guys. And like I said, I'll drop the Discord link in there. If you are into looking at documents, like I know some of you are, they have plenty of them in here. They have plenty of them in here, and I am going to put them on our Discord so you guys can read them. What'd you say? 30 years. As they just served 30 years. Here go the Discord link for anybody that wants to look at any of these documents that I'm gonna drop over there today. Okay, let's go back into our hearing.
Going to be objections, but I want to handle those after the state has identified which videos they're going to actually seek to admit. And you all have had a chance to review them, and then I will handle specific objections after that happens. Okay, so I'll reserve ruling on specific objections to any specific videos that the state intends to seek, or for that matter, any other evidence related to these 6 prior incidents that I am allowing into evidence. Okay, all right, so there are a couple of, other motions that were filed related to the gang issue. I know that Mr. Gonzalez, you have defendant's 3rd motion in limine as to gang affiliation, gang identification, gang charts. Ready to discuss that?
Yes, sir.
Okay.
Judge, this motion does have some dovetail effect.
Okay.
As it relates to some of the court's prior testimony, argument, and rulings. Essentially, the motion seeks to prohibit the admission of opinion testimony, again, identifying an individual as a member or an affiliate of a particular gang, defined in 874.03. Certainly, as the court knows, one of the things that the state intends on doing is admitting gang charts that would include victims of prior uncharged incidents, and probably seeking testimony as to those people and their deaths.
In state, are you actually intending to offer these charts into evidence?
Judge, we are going to use them as demonstrative exhibits.
Okay.
Certainly the same issue, whether they come into evidence or not, the jury obviously is going to see them, hear testimony about them, and the same limine issue, I believe, is still intact, and that is that I don't know and I can't anticipate the state's testimony. That's what these motions obviously are for.
Right.
But many or some of those individuals, whether they are killed by some other member of that or another gang,
I'm sorry, and are the charts that you're going to intend to use as a demonstrative, are those prepared yet, or they're going to be? They are prepared.
And they're exhibits in the motion, Judge, too. Okay. And essentially they include a bunch of people that are dead. And not only people that are no longer with us in the 6 incidents,
right,
but otherwise.
Yeah. Why do you need the chart?
Judge, I think it's a demonstrative aid, and there are a lot of gang members that are in the 6 incidents or in the videos, or there are actually other pieces of evidence that are either from the defendant's Instagram accounts or stuff of that nature, Judge. So that places them on the chart so that it can assist the jury to keep track of who is with whose group.
Is the state going to elicit testimony as to each one of those individuals as to what their gang criteria is, how they are documented as a gang member, under what circumstances? Because again, a picture of someone.
Right.
Judge, no, and we may further modify and take some people out, Judge.
Yeah. So what I'm going to do, I'm going to reserve ruling on the gang chart. State, you're not going to use it in opening. Okay. And you need to be very conservative, even though it's a demonstrative aid. You need to be very conservative in who you put on that chart.
Yes,
and honestly, that to me, this is more of a discussion about whether or not you can use it in closing arguments, depending upon what the evidence is. Okay.
Yes,
So that's my initial thought on the gang charts.
And so the court's just going to reserve until we see another exhibit.
I'm going to reserve ruling, but I am going to specifically find that the state cannot use that demonstrative in openings. Okay. So we just need to see what the evidence is. And then we'll, as we get to closings, we'll see if there's further objection. Then I'll let you know if they can use it as a demonstrative in their closing argument.
Judge, the next area of the motion is the actual documentation of Mr. Murphy, of Rashad Murphy. The court heard testimony from Detective Griffin, who is allegedly the person who follows and has specialized knowledge as to 1200, and documented Mr. Murphy as a 1200 gang member a month after this shooting took place. He was not previously documented as a gang member, only having done so July 23rd, a month after this particular murder, which is curious in and of itself. Now, granted, the position is, pursuant to testimony is, well, we can document somebody anytime we want. We could have criteria for them in 1921 and not document them until 1924. I said, well, even if you've already got criteria under the statute, isn't that the point of this? To have everybody know, law enforcement and other related people that have access to the fact that somebody's a gang member? Well, yes, but there is no timeline. Everybody does it differently. Everybody has their own style. Some people document after 2 criteria, some 3, some 4. But the gravamen of the situation at this particular juncture is, number one, Mr. Murphy was documented as a gang member a month after the shooting took place. Secondly, although I recognize there is statutory criteria that document somebody as a gang member, and certainly I can take issue all I'd like as it relates to that criteria and what it means in and of itself. The one thing that is undeniable is that in order, I believe, for testimony to be heard by a witness, in particular a gang investigator, that testimony still can't be hearsay. And it's the same admission standards as it would be any other type of evidence. And in this particular case, Mr. Murphy is documented a month after the shooting because there's been a documented, reliable informant that identifies him, A. B, he adopts the use of hand signs. C, he associates with one or more known criminal gang members. And D, he's observed in the company of one or more gang member 4 times or more. Again, it's a statute. I'm halfway in shock, but it's a statute. And essentially, the first category, that being that Mr. Murphy is subject to a reliable informant, that is really not the case. It's a reliable documented informant. The informants, 2 of them, that Detective Griffin, or not even Detective Griffin, by the way, Judge, not Detective Griffin, somebody before Detective Griffin, documents Mr. Murphy with, is somebody who stopped for a possession of marijuana misdemeanor. They have a list of people when they're doing whatever investigation they're doing on that misdemeanor of marijuana. Hey, do you know so-and-so, 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 and so-and-so, and Rashad Murphy? And are any of them gang members? Yeah. Maybe number 3, number 5, number 7, and Rashad Murphy are gang members. So that is supposed to be check, an indicator of his documentation as a gang member with no name, no date, no incident as it relates to the stop. Doesn't tell us where, doesn't tell us why Mr. Murphy is a gang member. It is that statement from a stranger under those circumstances that is going to be testified to as Mr. Murphy's gang criteria number 1. That happens twice. Same circumstance. And I won't go into the second set of facts, but extremely similar with no direct evidence as to anything other than it happened. Secondly, the second criteria, I believe, lacks foundation and is entirely speculative. This particular circumstance happens where Detective Griffin says, yeah, I saw Rashad Murphy give a hand signal. And he points and I said, what is the hand signal? He says, well, I can't really do it. I mean, I can't really tell you exactly, how it's done, but it's in a video. So we can look at a video, and I'm not a gang investigator. And certainly Detective Griffin says, yeah, well, hey, you look at that. But there is no specific movement in hands or presenting a signal or a handshake that I believe is shown within that video. That's criteria number 2. Third criteria is that Mr. Murphy is allegedly identified as a person depicted in a music video, not one of the ones that we're talking about. And it wouldn't be Detective Griffin that can identify him based on having looked at that video, because he hasn't had and didn't have any interaction with Mr. Murphy. It would be something told to him by another detective. And on top of that, as it relates to identification, I think the law is clear that someone can't identify someone based on a prior interaction with them, when in fact the jury can look at a video, if that's what the state's objective is, and decide whether or not it's Mr. Murphy or it's not Mr. Murphy. But the way that it dovetails into this argument is it is a criteria which the state is going to rely on to be able to provide the testimony that Mr. Murphy is a gang member, which, as the court certainly knows by now, that is a critical statement to be made for the jury's consideration, considering the totality of the evidence here as the court has ruled to be admitted. So to that extent, I would just argue that first, a witness cannot testify to a legal conclusion that an individual is a statutory gang member because it is based on hearsay evidence. And we still have to go back to the evidentiary foundation as it relates to testimony at a trial. And I believe that the case law would buttress that. There's a distinction between the state offering fact-based testimony for which a jury can determine whether a legal element is satisfied. And there's a difference between whether it's opinion testimony based on maybe not even what that detective did, but what a detective before him did. And I would suggest to the court that that's impermissible. And I think that's what the state intends in this case. It's going to present evidence that is, and it can't present something that is a statutory conclusion that's cloaked in some type of official authority.
Well, you're saying that the detectives, if they testify as a quote unquote gang expert, that they can't tell the jury that any of the defendants meet the statutory definition of criminal gang or criminal or criminal gang-related activity, correct?
And not especially as it relates to Mr. Murphy. I don't know about in general based on what the evidence is and based on what they're going to testify to. I don't believe the state can rely on hearsay to establish gang membership. And that I think is reflected in the case law in the Fossum case and in the McGill case. And essentially in Fossum, the state found that recognizing that although experts may rely on inadmissible evidence, that it may not be used as a conduit for evidence and may not testify regarding their consultation with others. So that is, I think, an issue in McGill, holding that the trial court's reliance on hearsay testimony regarding a defendant's gang affiliation in rendering sentence. This is a sentencing case.
About McGill?
Yes, it's a sentencing case. I require reversal and new sentencing hearing. And although I understand that certainly evidence that might be admissible in sentencing may have a different admissibility standard as it relates to trial, usually admission of sentencing evidence is broad and more easily attained than what would be allowed in a trial.
Well, in that case, I guess at sentencing, the judge, it says the trial judge improperly relied upon unsubstantiated allegations of McGill's gang involvement in the form of objected to hearsay from a police detective.
Correct.
Once the truth of the hearsay information presented at the sentencing hearing was specifically disputed, the state was obligated to carry its burden of corroborating the accuracy of the information.
Correct.
So hearsay, it's admissible. You would concede that hearsay is admissible in an expert opinion, correct?
Well, as long as it is relevant and as long as it is within the bounds of the rule.
And has some indicia of trustworthiness?
That's correct. Judge, as it relates to identification of the defendant through music videos, we're gonna hold off on that. The court has.
Yes, I really just would prefer that we not talk in the abstract, and that when it comes time for me to rule on those specific objections, that we have the actual exhibit, so that way I can look at it if need be. So,
Judge, understood. Admitting improper opinion testimony in this particular case, gang affiliation, is even more uniquely inflammatory. Now, granted, evidence that you don't like or evidence that may, in every case, there's going to be prejudicial evidence. That's the nature of a trial. But in this particular case, in my opinion, it's going to invite the jury to associate potentially Mr. Murphy with other individuals that may have and may be properly designated as gang members. I can't tell you that. Counsel, if they choose to, are going to have to argue individually about the criteria used and the evidence used in order to make that designation. I can only speak as it relates to Mr. Murphy, but it also has a substantial likelihood, again, of a spillover effect as it relates to his association with anyone else involved in the case. Concluding, Judge, I'm not suggesting to the court that admissible factual evidence related to gang affiliation be excluded. What I'm suggesting is that in this case, normally I would say witnesses, but the only witnesses in this case that are going to talk about anything in terms of Mr. Murphy's gang affiliation or involvement with others are going to be law enforcement officers that that relying on hearsay to the extent that they are, and in addition to substantive interpretation, which that's part of the motion, and with particularity that you'll read with regard to those lyrics in other motions that I've drafted, and improper opinion identification that establishes that classification, its prejudice is outweighed by its probative value if it's even relevant. I am suggesting to the court that the motion limit be granted as it relates to testimony from detectives that offer legal conclusions that an individual qualifies as a statutory gang member based on the means and manner upon which they gained that information, and not providing the foundation for its admissibility. Now, it would be a different story if we could cross-examine a detective regarding a report that was written where so-and-so on a particular day, based on this particular knowledge, told us that Rashad Murphy was a gang member. Okay, that may be hearsay, but it would indicate to us the specificity that would allow us to rely on that opinion. And we will not find a single instance as it relates to Mr. Murphy, and I might even suggest some of the other defendants, whereby a detective is going to tell us when something took place, who it took place with, where exactly it happened, other than to tell us we stopped somebody for a misdemeanor possession of marijuana, we gave him a list of people, and he tipped off the number, however many number that might have been, based on what the list was. He's a gang member, he's a gang member, he's a gang member. That's it. And when I asked about, well, was there any other particularized information that was given? And the answer was no, it was general information. So to that extent, Judge, I believe that it should be prohibited in limine. And certainly that would extend to hearsay based gang classification testimony, as I've just talked about. It's improper, and I believe it should be prohibited.
Okay, very good. Thank you. State, what's your response?
Judge, pursuant to statute 874, law enforcement is permitted to utilize a reliable, documented informant statement regarding each of the defendants' gang affiliation. In addition to that evidence in this case that we have for Rashad Murphy and his affiliation to 1200, we do have several, at least 3 music videos that were listed in discovery. We received notices on those music videos of our intent to rely upon them and the contents therein. Those were certified and provided to the defense as well. In each of those videos, the defendant is meeting several of the other criteria, of which obviously the witnesses are permitted to testify about their opinion as to who is depicted in those videos, because they're being listed as experts. They're certainly in a better position when they're viewing those videos to determine who is depicted in them. The defendant is, in fact, in many of the screenshots that I have, and I can show the court, I know the court asked for specific examples, but utilizing hand signs, which have been identified by law enforcement as those meaning that the defendant met the criteria. Is the court interested in actually seeing those today, or did you want to wait on that? I know there are kind of a blend of arguments being made with this particular motion in limine, so I'm not sure what the court.
Well, at this point, I'm just going to broadly rule on the motion in limine, and then once the state has again identified all of the exhibits they intend to introduce, we can revisit if there are specific objections to any of those identified items of evidence.
Yes, Your Honor.
So we're just kind of talking generally at this point.
I will say that there is direct evidence of the other factors that are utilized or testified to by the detectives, which deem the defendant, Rashad Murphy, to be a gang member. That is in at least 3 of the music videos. He is utilizing signs, being depicted in those videos with other gang members. And certainly as gang experts, I'm not getting into that argument, they're permitted to testify about those observations that are being made. And also we have the videos and screenshots from those videos which depict the same. Also the defendant's correlation with other gang members is documented in more than just those music videos. So in addition to the firearms and gang signs that are used in those, he had been stopped with other gang members. Those stops were documented, and law enforcement relied upon the information that was retained in those results as well. Law enforcement themselves have testified that they directly saw the defendant utilizing several of the accounts that they saw evidence of gang activity on. So there's certainly a sufficient amount of direct evidence. I understand that the argument from defense is being looped into this one element from the gang statute that a reliable informant gave a statement to law enforcement, but there are several items of direct evidence, including those music videos, the stops, the defendant's use of gang signs, that the state intends to rely on to establish his actual gang membership. That being said, I want to just draw a distinction between the agency's documentation of each of the defendants as gang members, and that being separate and apart from whether they meet the statutory criteria and what the state has to prove at trial, as far as whether in meeting that statutory criteria, the crime was committed in furtherance or in progression of the gang's objectives. So I understand, again, the defense's arguments regarding the dates and times of the documentation, but essentially it's the state's burden to prove that these things were met at the time that the crime occurred, not what each agency did.
And what's your position on your law enforcement witnesses being able to tell the jury that in their opinion, any one of these defendants is a criminal gang member or associate? Is that not invading the province of the fact finder?
I believe they can testify as to each of they're going to testify that they have documented several items of.
Sure, they're going to testify to the statutory factors.
Yes.
Correct. And in there, and what supports the statutory factors. But as far as the ultimate conclusion, isn't that ultimately the jury's decision to make?
I think the conclusion that the witnesses will make are that they are documented with the Jacksonville Sheriff's Office as a member of 1200, documented with the Jacksonville Sheriff's Office as a member of 6 Block, instead of making a general conclusion that they are documented gang members that killed Charles Jones in furtherance of the gang's objectives.
Okay.
2 separate things in the state's opinion.
Okay. All right.
Judge, quick rebuttal. Were you going to?
No, yes, thank you.
Judge, number one, this confidential informant is neither documented nor reliable, so I would take issue with that representation. At least I understand it's coming straight from the criteria under the statute, but in this particular case, neither of those things are actually accurate. Second of all, I don't believe that any of these detectives are in a better position to look at a still shot, okay, of a video and look at Mr. Murphy and make a determination whether or not that's him.
Well, maybe yes, maybe no. And again, that's going to be very item of evidence specific.
Yes, Judge.
Okay.
And I also asked the court to reserve ruling as it relates to whether or not any of the music videos would indicate or show Mr. Murphy utilizing gang signs.
Okay. Okay. All right. So as to the defendant Rashad Murphy's third motion in limine, I've already ruled on the gang charts. With regards to gang affiliation and gang identification, I'm going to deny the motion. But again, generally speaking, Mr. Gonzalez, you can always raise contemporaneous objections at the time the testimony is coming in as to any particular factors that law enforcement is going to rely upon. And with regards to the ultimate finding, whether or not these defendants, any of them, meet the statutory definition, that's not for law enforcement to opine or render an opinion from in front of the jury, because that's going to be a fact that the jury has to find as to the three defendants where the state is seeking or has notified those defendants that they're seeking to have them identified as a criminal gang member or associate.
Judge, in clarification, are you saying that the state's prohibited from eliciting testimony from the detectives that Mr. Murphy has been documented as a gang member from 1200?
At this point, yes, I am. Okay. So law enforcement can testify as to any and all of the factors, and law enforcement, for example, Detective Nieder can tell the jury there is a statute that is utilized, and these are the factors, and this is the evidence that supports the factors, but that ultimate conclusion is for the jury to make. Okay.
Your Honor, Nixon already on behalf of David Murphy. Obviously, we're going to join in on the motion to exclude any designation of Davion Murphy as either an associate or a gang member. My understanding as it applies to Mr. Davion Murphy, I've been provided a photograph from the internet that goes back to 2016 that shows Mr. Davion Murphy with Noah Williams and Reginald Williams, who I believe were documented 1,200 members. That's the only thing I'm aware of. Mr. Davion Murphy is not depicted in any music videos that I'm aware of. The only gang sign that I am aware of that alleges that Mr. Davion Murphy is a member of any gang is at the interview that was conducted in Jacksonville, where he is singing to one of the rap songs, and during the course of that singing, allegedly makes instantaneously a gang sign. And again, he is in no social media that I'm aware of. The designation by law enforcement that Davion Murphy is allegedly a gang member, a gang associate, occurs after the homicide here in Tampa. He is not even known to Detective Griffin, who was the gang detective for the 1200 gang, as I recall his testimony. So we would also ask the court to exclude Mr. Davion Murphy designation as even a gang associate.
Okay, thank you. I will deny that motion, but again, the same ruling applies as to your client as it does to Rashad Murphy. Okay? Okay. And let's see here. I know that Mr. Gathright filed a motion in limine to preclude any reference to the defendant as a criminal gang member or associate. You want to discuss that one further, Mr. Wise?
I don't know that it's necessary. I think we kind of addressed it earlier. I mean, it's almost like he just dropped in one day. No one actually knew who he was. There's no connection. The only alleged connection is apparently talking to Mr.
Well,
Chance.
State, are you going to seek to elicit any reference or designation as Mr. Gathright as a criminal gang associate?
Judge, no, now that, Judge, we did not list him under the enhancement in the indictment.
Okay, so that motion is granted.
Thank
Okay. Okay, let's see. Okay, let me go to my next pile of motions.
Judge, Judge, did you rule on Rashad Murphy's first motion in limine regarding those from 97? Because I thought.
No.
Okay.
Nope. You want to do that one next?
Yes, Judge.
Okay. Mr. Gonzalez, you're up
Is
again.
there one we might be able to do in the interim so I can catch up?
Yeah, sure. Let's do, I tell you what, eeny, meeny, miny, mo. Let's go with Davion Murphy's motion to, C4 motion to dismiss.
But John Nixon already for the record. We did obviously file a C4 motion, and concisely the evidence, although the state did file a traverse, the evidence as it applies to Davion Murphy is basically alleged that phone records tracked that was supposedly his phone from Jacksonville to Tampa prior to June, I believe it's 22nd. He is then seen supposedly in a vehicle at a McDonald's going through the drive-through on June 23rd. The next time they allege that Mr. Murphy, Davion Murphy, is seen is in a security video at the Airbnb. There is no phone records that place Mr. Davion Murphy either at the clubs that are allegedly visited prior to the homicide or at the Home 2 suites. The next time that Mr. Murphy, Davion Murphy, is allegedly located, or again, supposedly phone records going from Tampa to Jacksonville and the license plate readers. He is not identified at the scene of the homicides, and that is substantially the state's case, and that's what we're alleging. That's insufficient as a matter of law to survive a directed verdict.
Okay, thank you. State, any argument? I know you filed a traverse. Anything further?
We rely on a traverse.
Okay. That motion will be denied. Okay. Let's see.
That's so funny. Like the state didn't even respond to that request for him to get a direct verdict of acquittal.
Davion Murphy's motion in limine to exclude the office of the state attorney from indicating or intimating that Davion Murphy is affiliated with ATK or 1200 Block or any other gang.
I believe that goes along, that was on behalf of Davion Murphy.
Oh my
That goes along
God,
with
look at all them tattoos on him.
discussions and arguments by all counsel thus far.
Okay.
So I would rely on those arguments. in
Okay.
your previous.
All right. So again, the motion will be denied. However, defense reserves the right to make specific objections to specific items of evidence or testimony. All right, but the motion is denied.
Yeah, they are so cool. It's ridiculous. You need to wear a turtleneck during trial and cut his hair. Oh yeah, he was in a baton. So it's his girl. Yeah, I
All
love
right,
her.
let's see. Mr. Chance has a request for judicial notice. And essentially you're asking me to take judicial notice of the fact that Miss Andrews was convicted of manslaughter on October 31st, 2025. Is that correct?
Yes, it was indicted in the same
Okay.
as well.
Judge, I would like to be heard. Obviously, Judge, you were the judge and presided, and that
Right.
is what happened. But I do have concerns and do want to raise at this time. Obviously, what happened with a co-defendant
Right.
does not get to be mentioned in front of this jury. And I would ask that all the defense attorneys in this case, what specifically was found in her case is not admissible in this case, Judge, and should not have any bearing and should not be referenced as to that jury's actual findings and verdict.
Okay, well, the gist, all that's here is a request for judicial notice. So
Well, Judge, but the state has concern. Why is he asking for judicial notice?
I don't
Are
know.
they trying to argue?
I don't know.
Is there a similar circumstance in the same car?
But you weren't going to try and get into that in guilt phase, are you, regarding what the verdict was of the Andrews co-defendant?
Well, my motion would be, my request would be for both, but I think specifically, I think it's especially relevant in the penalty phase.
Well, that wasn't the question. I asked you about guilt phase.
Well, my answer would be yes.
Okay, well, I don't think you're going to be able to get into it guilt phase. Penalty phase may be a different story. We'll see.
Yes, sir.
Okay, so,
And Judge, I'll file a motion limiting. I didn't know what his intent was, but obviously we don't believe that that should be mentioned or referred to in front of the jury for guilt phase.
I agree. Okay, I agree. It's not relevant for guilt phase. It may be for penalty. Okay, so even though there's not a specific motion pending, I will grant the request. I will take judicial notice if it is a relevant issue for me to take judicial notice of, just so we understand each other. That's not admissible evidence in the guilt phase of the trial, okay? Penalty phase may be different. So technically, I'm granting the request as that's granted. I mean, as it's proposed. Okay. Mr. Gonzalez, or you want to address the Ghost 187, or you want to do that after lunch?
No, Judge, we can do it.
Okay. And this would be defendant's first motion in limine.
Yes, Judge. This is a motion in limine seeking to prohibit any admission linking the Instagram account Ghost 187 to the defendant. A quick backdrop, Judge. As you know, you've heard some testimony earlier that Ghost 187 was provided initially by Detective Drabeck to Detective Ramos in the very couple of days inception of the investigation. And that's kind of what buttressed the Chevy Silver Cruise and part of the probable cause for the affidavit, a search warrant affidavit for the cell phone and for the vehicle. On June 23rd, within that Instagram account, ghost187__, the account included 3 items: an image of Tom Brady and Bill Belichick celebrating a Super Bowl victory. Number 2, a black screen containing 4 crying, laughing emojis, and a black screen displaying the phrase "Prosper and Junior G Day today, 187 babies." The defense believes that the state's going to attempt to elicit testimony with the opinion that Ghost 187 is an account owned by Rashad Murphy or operated by Rashad Murphy. And also, unless they tell me otherwise, they're going to seek testimony from detectives interpreting, at least for one thing, the meaning or what Prosper and Junior G Day today, 187 babies means. Let me just ask real quick, are you guys still going to do that, considering we're not getting into incidents that happened before the 6th? I just want to, that's fine.
Yes.
I got it. Okay.
Yes, and I assume you're maybe seeking clarification for getting into prior incidents before.
Just clarification for my argument, whether I need to. So essentially, Judge, detectives are going to speculate and they're going to provide testimony that Prosper refers to Prosper Johnson, a suspected 187 gang member who was killed in 2014, which obviously would be an incident that was originally within the table and the number of incidents that detectives testified in deposition. That was part of my prior motion, and certainly understanding that the court has limited the prior incidents to those that occurred in those 6 circumstances, this not being one of them. Because what the detective is going to testify to is, in his opinion, that Prosper refers to Prosper Johnson, who was killed in 2014, that Junior refers to Gerard Adams, a relative of the defendant who was killed in 2018. And he's further going to opine that G-Day means get back, and that the post reflects retaliation for the deaths of Johnson and Adams, namely as it relates to Charles Jones being killed in reprisal. And so certainly that's of concern to me for a number of reasons. Number one is that, again, they would have to foundationally determine that Mr. Murphy owned or operated that Ghost 187_. And secondly, it dovetails into the type of opinion testimony that doesn't include specialized knowledge. It's simply saying, this is what I believe this says. Again, this is not coded language. This is not language that's being used over and over and over again in some underbelly of communication between gang members. And I would suggest to the court that in a sideline, in an underscored situation, that's improper. Going back to the 187_, Ghost 187_, the account records indicate the subscriber as an Arindam, Arindam, Omerta Nimrod, and then a registered email address, which is ghost187official@gmail. No identifying information, obviously, that would have anything to do with Mr. Murphy. They do attribute Detectives Griffin and Nieder that account to Mr. Murphy. And in asking about that and in getting testimony under oath, I asked Detective Nieder, and he declined to identify the informant that told him that this was an associated account. And when asked to identify anything else linking the defendant to that account, he said, that's it, on page 32. Detective Griffin, who is a 1200, an individual detective who looks after 1200 on a daily basis, I asked, could he show me a screenshot or a post or a story that you've captured that would show Rashad Murphy in it from that Instagram account? No. Can you and will you testify under oath that you have monitored that Instagram account and you saw Rashad Murphy on it? No. Is it fair to say that your testimony is in that area as it relates to the Instagram account that would be somebody told you that it was his Instagram account? Yes, sir. Harken back also, Judge, to testimony last week from Detective Nieder when I asked him essentially the same series of questions. Have you ever seen him on that account? Well, yeah. When? I don't know. With who? I don't know. Who else was on live during the posting? on that account? I don't know. What were they saying? I don't know. Again, back to the overall issue and problem with the majority of the type of testimony I anticipate the jury hearing if the court allows it. Essentially, during the course of that deposition, the state asked some additional questions and said, hey, look, is there any other significance of 187? And Detective Griffin said, yeah, it's the penal code in California for murder, 187. And essentially, he conceded, though, that it's not known in the state of Florida that it has any significance, that it's not based on any kind of popular cultural type of reference, other than the fact that it's noted in a couple of gang-related movies, which is a problem in and of itself. And when I asked them whether or not it had anything to do with anything happening in Tampa, Florida, and certainly even more importantly, anything happening directly with Rashad Murphy, the answer was no. The other reason Detective Griffin gave for associating Mr. Murphy with Ghost 187 __, in addition to what I've just told you, which is in my estimation, clearly speculative and certainly not admissible. Detective Griffin said, well, he appears in some of these videos, not videos that are related to anyone being killed, okay, but he's in the background, and he's not really up front, and he's there and then he's not there, so I attribute that to him being the ghost, and that was his testimony under oath. Detective Nieder similarly testified, and I told you this about that he went live on this account at some point in time that he can't give us a date for, nor any other corroborating information for, and that is in his deposition on page 69. He also, Detective Nieder admitted that he had limited familiarity with the defendant. He did not know whether or not there were photographs of the defendant that came on this account. He was not aware if any photographs were posted to this account. He wasn't aware of any connection between the defendant and the subscriber name or the email address. And essentially, I believe that the state cannot link Ghost 187 _ to Mr. Murphy, nor can they offer any permissible evidentiary foundation for suggesting that Prosper and Junior G Day Today 187 babies has any relevance to Mr. Murphy. And I believe those posts can't be authenticated and they're irrelevant. I would ask the court to prohibit any testimony purporting to link Mr. Murphy to Ghost 187 _. Any evidence derived from Ghost 187 _ Instagram account, and any opinion testimony purporting to interpret that phrase. I have set forth in my motion, Judge, case law, rules of evidence, particular circumstances that I believe support not only testimony linking Mr. Murphy to that account, but also posts that are associated with that account, and essentially would suggest that the state lacks any subscriber records connecting him to the account, any evidence tying him to the registered name or email, any posts or photographs or videos depicting the defendant on that Instagram account, any admissions as to ownership of that account, and any forensic evidence that establishes any control or authority or authorship of that account. I would cite the court to the Tharp case, which is at 777 Southern 2nd 385, a Supreme Court case in 2000, that the state seeks to interpret and establish motive, namely that this charged offense was committed in a reprisal situation. And it's not a conclusion based on the explanation of the language that we're talking about here. It's an inference as to his intent. And in Tharp, the Supreme Court reversed a first-degree murder conviction and a death sentence based in part on the improper admission of a witness's interpretation of defendant's statements. The defendant's cellmate was permitted to testify that when the defendant said he did a hooker, that means he killed it and killed her. And the court held that this type of testimony was inadmissible because it's grounded solely in inference instead of any specialized knowledge or training. And I would suggest to the court that when you look at that, and even if you take into consideration any specialized training or knowledge, none of that would come into play when it provides the explanation that Detective Nieder did about his interpretation of that statement that was located on that account. And certainly I would suggest to the court that even if you did, certainly my objection as it relates to this motion, Ghost 87, that certainly an interpretation and an opinion statement by Detective Nieder should in and of itself be impermissible. Thank you.
All right, and I want to thank you, Mr. Gonzalez. In your memorandums, you put page numbers on your case law, so it did make it much easier for me to find what you were referring to. Okay, Ms. Smurr? So how are you going to prove that Rashad Murphy is somehow related to the account Ghost 187?
All right, good morning, everybody.
I don't know why they cut that off right there. Give me 1 second. Let me pull up the other part of it. So I guess while I'm pulling up that other part of the hearing, let me I'll get the other part to this. I just want to kind of I'll explain this portion here. Let me share it with y'all. Remove. And like I said, I'll put all these documents in Discord for anybody that loves reading documents. Once I done read it once, I really don't need to read it again. But let's see here. And then we'll go back into the hearing. Okay. So guys, this right here is the actual decision regarding, hopefully y'all can see it. Let me see if I can make it a little bigger for y'all. So this is the order that the judge did in regards to Sean Gaffright. So I'll just break down like what I saw in the document. And as I said, I am going to put it over there for you guys. So it's not just a small motion. This is in regards to the digital evidence and whether the police went too far. So the judge ruled, she granted it in part and then she denied it in part. And what that means is that the defense did not win completely, right, in the state. So it's kind of they splitting this baby. The defense filed a motion to suppress all the evidence obtained from Sean Gaffright's iCloud accounts. They were trying to get everything, completely thrown out, the photos, videos, anything that he had on there, basically the entire digital footprint. And the reason why the defense wanted it out is because the warrant was too broad. It was not properly limited, and it violated his Fourth Amendment rights. So they say. They claim law enforcement conducted what amounts to like a general search. So they were kind of like AKA fishing on a fishing expedition on whatever they could find in his account. They also argued that the warrant was not tailored correctly. It allowed police to search way beyond what was relevant, and it pulled data outside of the timeline. So what a law enforcement did, it started, the police issued a subpoena to Apple, of course, and they were looking for accounts tied to the phone number linked to Sean Gaffright. From that subpoena, they discovered 2 iCloud accounts, and then Detective Ramos submitted an affidavit. He got the search warrant approved by the judge, but the warrant included a date range from June 1st, 2024 to July 12th, 2024. That time frame is very important because it covered the planning phase, and it also covered the time that led up to the redrum of Foolio. So even though the warrant had a date range, Apple didn't just send from that date range. Apple actually sent the full account number, and it went all the way back to 2021. And that's the key issue, because iCloud backups are not selective. There are complete device backup. So when the police requested the backup, they often get everything. And so when Detective Ramos testified in the last hearing, he was saying that, the iCloud backups did come in and they had all the data on the phone, and they had no way to separate it when they request these types of backups. He also admitted he intended to review whatever Apple provided, even if it went beyond the requested date. So it brings in the vehicle and the connection to the vehicle. Because remember, he was arguing a lot of the things in regards to his vehicle being searched. So, on June 26, 2024, that's when they did the traffic stop and they stopped Sean Gaffright in that 4Runner. That stop alone, that's how they got the phones. And that's how the digital evidence started being looked at. So what the judge did in regards to it, she found that the warrant did have probable cause and that the affidavit met the legal requirements, but the execution of the search warrant was broad. So the judge noted that the data as far as back as 2021 was obtained. That goes beyond the scope of the search warrant, so they won't be able to bring that evidence in. So the only iCloud information that they'll be able to bring in for Sean Gaffright is going to be from June 1st, 2024 to July 12th, 2024. And that's going to cover what the state actually needs. So anything outside of that they got back, like they thought they was going to try to bring in from 2018, 2020, in 2021, any of that stuff, none of that's coming in from. So it matters because it was a close call, because if the judge had ruled that warrant was not good, all that iCloud data would be gone. So they get some of it in, but they're not going to get all of it in. So that was kind of a good thing. But let me get us, like I said, I'll drop those things in Discord. Let me get the rest of the hearing up for us so we can watch, because they just like blatantly just like cut it off. Now, remember, they are supposed to have a show cause hearing tomorrow on this case, and I'm pretty sure they're going to be doing some more preliminary matters, is what I am thinking tomorrow. I'm not sure if Law and Crime is going to show it live or not. If they show it live, then, of course, I will bring it to you guys live, but if they do not, then we'll schedule a stream in order to actually go over it. But let me get this shit. Yeah, because they I don't know why they pieced. I don't know if they didn't have time at law. I don't know why they did it like this, but a lot of this stuff is like pieced together. So let me get this up so we can continue watching the rest of the hearing. And then I think it's one more ruling on here that I'll be able to explain.
The fact that all of the motions have been ruled upon, all right?
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is with firearm motion.
Okay.
State and I discussed, I mean, I think it might make the most sense to kind of proffer and address it with the expert.
Okay. Well, I do have that one. So there were 3 motions that I located in my stack of pleadings, and I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied. And I think that was the CCP aggravator, which I denied. So that has been denied. Do you need it?
I'll just take it.
Okay. Okay, I think you did too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied. And that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures. And there were paragraphs. I think A was granted, B was granted. And C was granted as to the names, but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So Madam Clerk, that was granted in part, denied in part, as articulated. And okay, so I think those are the 3 motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members. And specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845-7-2nd-74. I did take a look at that opinion. And in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away. He adopted her 4 children and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo, he argued that that mitigating circumstance outweighed
reasons the court allowed the identification of that
on appeal was Mr. Lugo he argued that that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right. So yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case. Obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life. Okay. So, all right. Very good. All right. So let's move on to which would be Mr. Gathwright's defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
Your Honor, my position in the motion, I don't know if states are excuses, is that this firearms identification evidence is not product of reliable personal methods.
I'm sorry.
Yes.
I can't hear either.
This is better than courtroom one, but it's not, it's still a big courtroom.
So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts of Florida have not been particularly receptive to the argument.
Wait a minute. I thought this sounded like a repeat. That's why I was going through the thing. That part is a repeat. Let me pull us up. I'm like, this sounds like a repeat. Let me get who was up there the last time. Give me 1 second, guys. I don't know. I guess they just got this stuff on here all types of different ways. So let me get us together so we not listening to the same stuff. Let me go into my history. Wait a minute. View. Okay, let me see who was the last person to speak on here. Oh, it was him. It was him up there. Okay, we was at 2 hours and 25 minutes. Okay, let me get it. We 2 hours and. Okay, here we go.
Of views with regard to all of his different songs, and they are not all drill videos, and they are not all videos that troll or disrespect other people. It is an entire litany of a music catalog. Again, Judge, the state cannot link those firearms to Mr. Murphy in any respect, other than the fact that that picture was sent to him and was on his phone. And in that light, Judge, I would ask the court to prohibit their admission.
Okay, state, are you seeking to admit paragraph 26, items A through D? And if so, why?
Yes, Judge. 26A, the screenshot, it was posted, and this is a shared phone to Rashad Murphy and Charmaine Steiger. This is a phone that Ms. Steiger originally said shared, and they equally used, and was found in the defendant's possession. Later, she has recanted and said that it was her phone solely. So obviously, proving attribution is also going to be the state's burden as to who actually uses this phone. We would be willing, there is a Jacksonville homicide scene that is part of it. We would be willing to redact that out. What we are interested in here and what is relevant to this particular case is that on that day, he is tagging Young and Ace's song. and that was captured in a screenshot. And obviously, Young and Ace is the member of ATK, is one of the founding members, and predominantly in some of these videos that are directly relevant to this case, including videos that were posted after the victim was dead, detailing his death, that were posted a few days after the homicide. As to B, as to the photos of the two rifles, they are sent June 20th of 2024 is the timestamp that is in the defendant's shared phone. Again, these two phones match the appearance of the rifles that are used in this case. And there is another connection to Sean Gathright. That same photo is found in Sean Gathright's phone. So that is very relevant, highly probative, and outweighs any prejudice significantly. On June 22nd, that photo, again, we're not interested in the phones and anything else in it, but that is the one photo that we have. It's not really discernible in the video footage from the Walmart of the type of boots that he's wearing. And he's wearing black combat boots. That and everything else that he's wearing matches one of the armed mass shooters in our case. And this is a day before the homicide occurs. And D, June 22nd, the screenshot of text messages with instructions to prison security gates. We are agreeing not to go into that.
Okay.
Judge, we have one short 2-second rebuttal, and that would be as it relates to IFA, Judge.
What was the Young and Aces song that was tagged?
I do not recall. I don't believe it's one of the ones that the state's going to be entering. That would be number one. It is not one of those songs. And second of all, Judge, they said the defendant tagged the song. They don't know that, and I could be wrong. My understanding is anyone could have done that. That's the way it came. And to suggest that there's a link because Mr. Murphy tagged that song, I don't think that's exactly the circumstance. Anyone could have tagged that song. It's on the phone, but I don't believe there's any evidence that would suggest it's Mr. Murphy that did so.
Okay, so just so I'm trying to understand exactly what this is, it's a screenshot on Mr. Rashad Murphy's phone that depicts a homicide scene with the Young and Aces song tagged as part of the depiction of the homicide scene. Is that
And it's kind of a
correct?
faraway shot.
We can show you on our computer if you want to see it.
Yeah, let me just. And remind me, what is this relevant to, state in your opinion?
Judge, it's relevant because Young and Ace, who is a member of ATK, this again is going to be corroboration of the gang expert's testimony that 1200 and ATK are allied, and they're allied against 6 Block. And again, this is on Rashad Murphy, a documented member of 1200, and it is relevant because he has on his phone a screenshot, and just like Mr. Gonzalez says, it's going to be at issue attribution, who this phone is being utilized for. We have it with Mr. Rashad Murphy when he's at the Walmart. We have it in the vehicle, the suspect vehicle, when he is arrested. And of course, it never comes to Tampa. So this is a shared phone between him and his girlfriend, Charmaine Steiger. But obviously, with the additional other information that is located on that phone that is relevant to this crime, any sort of connection to the gang is important and probative. But again, this is I know we are not suggesting this Jacksonville murder. We have been explained that it is a Jacksonville youth that is depicted in that picture. We would redact that out. We're not going to go there. I am more interested in the fact and that Young and Ace's song is specifically tagged and is screenshotted on his phone.
By someone and could have gone to tens, if not hundreds of thousands of people as well.
All right, I understand. That kind of goes more toward the again weight. So I will, on 26A, state stipulates it's not going to introduce the photo of the Jacksonville homicide, so it's granted as to that and denied as to the remainder of 26A. 26B is denied, 26C is denied, 26D is granted. Okay, I think that's it from that motion, correct, Mr.
Judge, 26C granted in part.
Well, it's a photo. The photograph itself does have relevance because it does show the person in the photo with the, according to the state's theory, the similar black combat boots and black pants. So that for that purpose, it is more probative than prejudicial. So I denied it. Denied the motion and limited to keep it out. So I think that's it for that motion, correct?
Yes, sir.
Okay. Okay. Davion Murphy, defendant's motion in limine.
Judge Lee, obviously, Nick Sonardi again for Davion Murphy. We've argued the certification of Mr. Davion Murphy as an associate of gang 1200, so we're not going to reiterate that. That's already before the court. We're arguing paragraph number 2, and that is that the state may intend to introduce the fact that there was a gap of about 6 months from the time that the warrants were issued for Mr. Davion Murphy's arrest until the time that he was in fact taken into custody as consciousness of guilt. I submit all that they have, basically, as I understand it, is the time frame itself, and not that I'm aware of. In fact, as we speak, I'm still not absolutely certain how it was that Mr. Davion Murphy was even identified to be arrested. That I don't have that information. But we would allege that there is no consciousness of guilt simply because of the time frame from the issuance of the warrant for his arrest and the time that he was actually arrested.
Okay.
Just, I'm sorry, what motion are we on? Because
It's Davion Murphy. It's titled Defendant's Motion in Limine. And in that motion, Mr. Sonardi is asking, 1, that the defendant's prior certification of being a gang member of the 1200 gang be excluded. 2, the approximate 6-month lapse in time of the defendant's arrest following the issuance of defendant's arrest warrant. And 3, photos of the deceased victims. What are you referring to when you say the photos of the deceased victims?
I'm sorry.
When you say photos of the deceased victims,
Right, the autopsy photos. Oh, I'm sorry. It should be victim.
yes, that confused me a bit.
I'm going to ask the court to reserve on that. We wait to see which photos exactly the
Okay.
state intends to introduce. We can address it at that time.
Okay. So are you now with me on what motion this is?
No, Judge, I don't think I have that one actually, but I can, if we go one by one, I'll be able to respond.
So the first one is the defendant's prior certification of being a gang member of the 1200 gang. And are you talking about a gang expert testifying as to Mr. Davion Murphy being previously certified before he went to prison? Is that what you're referring to?
That certification expired because of the 5-year lapse. So now he's been designated in some
Yeah.
manner, allegedly as an associate of the 1200 gang.
Okay, so state, do you agree as far as the prior certification?
Judge, sure. No, Your Honor, I think that Mr. Sonardi's argument is regarding the earlier certification from Jacksonville
Right.
and Mr. Murphy's affiliation there. He still meets the statutory criteria. So it changes nothing about the state's argument because he went to prison and then in prison still met the criteria just under the Cutthroat Gang instead of a 1200 designation. So he still met the criteria. If the argument is that Jacksonville would be permitted or not to testify that he was in fact documented in Jacksonville before he went to prison, then the state has no objection. That's accurate.
That's what I'm hearing, is that you're talking about the previous certification
Correct.
before he went to prison.
Correct. And my understanding is under 874 that previous certification expires after
Right.
5 years. And that he would have to be recertified, which he was not. He was designated as an associate.
Right. Which is what the state's seeking to prove, that he's an associate, not a member, correct?
That Mr. Davion Murphy
Yeah.
is a gang member.
I thought you told me associate.
Judge, I believe he is.
He meets all of the criteria for gang member before and after.
I thought I read somewhere that Isaiah Chance, member of ATK, Rashad Murphy, member of 1200, Davion Murphy, associate of 1200.
Member of 1200, the only associate label that has been lodged against any defendant is for Sean Gathright because of the criteria of association. Davion Murphy, both before and after his release from prison, met more than one criteria.
Yeah, the yes.
Well, I'm not clear exactly as to what it is, the criteria that the state is relying on to certify Mr. Davion Murphy as a gang member of 1200.
Yeah, I don't know. I can't recall now where I read that because I had made a note a while ago that the state was seeking to prove that Rashad Murphy and Isaiah Chance were members and Davion Murphy was an associate.
Correct.
So since there appears to be some confusion, I would suggest a.
Judge, I can speak to that.
Okay.
Early on, when we went to the grand jury, he was qualifying as an associate based on the prior certification and the fact that after he went to prison, Mr. Sonardi is correct that they were purging their records. However, based on the fact that he still had that tattoos, he still met the criteria of associate. Mr. Harmon has uncovered some Department of Corrections that we are working to get the STAR report, which shows that he still, even when he went in prison, was connected to a gang. It was a prison gang. And so factually, we believe that we would be able to present enough evidence to the jury to show
that the defendant was a gang member and met the criteria when the offense occurred.
Well, correct. We don't have that evidence. That I understand what the state's intentions are at this juncture, but we do not have that.
We do in fact have multiple.
Okay, it's supposed to be one attorney per motion, just so you all know. So for the state, I need one person to argue this motion. Okay, it's fine. So this needs to be sussed out a little bit more, it sounds like, because I was under the impression the state was going to attempt to establish he was an associate, but it sounds like Mr. Sonardi, now they're going to attempt to establish he was in fact a member. So regardless, it would be at the time of the offense, and his prior certification would have lapsed, expired, right?
Judge, the prior certification was based, or should be based if there is nothing within the 5 years, Judge. That is not accurate.
Okay, so I tell you what, okay, I'm going to reserve ruling, Mr. Sonardi. We just need to see how
we can sort it out.
Yeah, how we can sort this out, and state, if you've got additional evidence, you need to get it turned over ASAP.
And Judge, the majority of the evidence has already been provided. There was just an additional STAR report that we're waiting on.
Okay, and then with regard, are you going to argue consciousness of guilt for the 6-month lapse between when the offense occurred until
Yes, Your Honor.
Okay, based upon what?
Judge, there was a high-profile media press release that was done both by the Tampa Police Department as well as the Jacksonville Sheriff's Office when when the arrest warrants went out for all of the defendants. There was a press conference that was done, and 3 of the defendants immediately were arrested. And there was various attempts by Jacksonville Sheriff's Office to locate Damian Murphy in Jacksonville, and he was able to evade law enforcement for several months.
So you've got witnesses who are going to testify what they did in an attempt to locate Mr. Murphy and take him into
Your Honor.
custody?
As well as the video footage of the defendant the day that he was taken into custody. There are several statements that he himself makes when he's waiting for law enforcement to come into the room, where he is talking about how the best place for a person to hide is in plain sight. So there are statements that are made by himself on that video that shows a nexus that he was purposely hiding from law enforcement in this case.
Okay. All right. As to item 2, I'm going to deny the motion. That sounds like a weight versus admissibility. So reserve ruling on paragraphs 1 and 3, and then deny as to paragraph 2. I think that's it for that motion, right?
Yes.
Okay. Very good. Thank you. All right. Isaiah Chance, motion in limine. I think we may have covered a fair amount of this already.
Justin Petrides, behalf of Mr. Chance. For number 1, Judge, prior crimes, I'm really talking about 3 things. The October 7th attempted murder of Charles Jones, but I don't think the state's going to, I think they've stated they're not intending to.
They're not going to, no witness is going to take the stand. If it's an unsolved homicide, no witness, including law enforcement, is going to take the stand and say, well, I think it was.
Sure.
No one's going to opine.
And that goes to my other issue was doing some detective.
As far as who the perpetrator was.
Correct.
Right. Okay. Right. So
some detectives mentioned that they believe Mr. Chance is involved in other unsolved homicides, which is the same issue.
Yeah. So that's granted.
And then he was arrested for resisting without violence during this case. I'm asking for that not to come up in this case.
Okay. He was charged. He was not charged with that, right?
Not in this indictment.
Okay. Okay. Granted.
And I think number 2, you previously ruled on, that's the.
Yes. So same ruling. Paragraph 3. Well, I've already, I guess in the context of Mr. Murphy's motion, I've already ruled, so that would be denied. Okay. And paragraph 4. Again, at this point in time, I'm reserving ruling on the introduction of the rap videos until I know what the universe of proffered evidence is. So I'll reserve ruling as to paragraph 4. So then we've got the issue of Davion Murphy's alleged statement after the death of Charles Jones. That kind of goes into our severance issue, so I'm going to reserve ruling on that one, whether that would in fact be admissible against any of the other co-defendants if they were tried separately. Item number 6 has to do with the items found in Sean Gathwright's car. That will be denied. 7 would be the search of Sean Gathwright's home. That will be denied. Paragraph 8 would be the items found in Mr. Chance's residence. I think the state agreed to some
Yes, Your Honor.
correct? So it would be as previously ruled.
And then I think you wanted to see the picture of the Glock switch.
Yeah, the notes. Yeah, I need to see that. So I can't even remember now. I think I granted some, reserved ruling on some. The clerk has my notes, so I can't remember. So as I previously ruled in the motion for that Mr. Gonzalez argued on behalf of Rashad Murphy. Okay, and then we've got the Glock 9mm and the firearm. I think the state agreed to that one, right? With regards to Mr. Chance?
Yes.
Okay, so that one's paragraph 9 is granted. Paragraph 10, the bully down poster, that's denied. 11, the notes, that's the one I've reserved ruling on.
That's an error, Judge. I put that twice.
That's fine.
Okay.
12,
This goes to the history. This is,
okay, that one is denied. 13 has to do with the social media post on November 19, 2023.
goes to allowing an expert to interpret the social media posts.
Okay, and I'm assuming, State, you're going to seek to introduce this?
Yes, Your Honor.
Okay, so that one's denied. 14, Cash App transaction.
This is both the transaction and describing what an expert believes the basis behind the transaction is. It's simply a transaction of Corey Rivers paying.
Right, this is for the Airbnb though, right?
Yes.
Okay, right, so.
Corey Rivers is not going to testify.
Right, but I mean, the fact that the transaction occurred is admissible, you're just saying no one can opine what the reason was.
Correct, Your Honor.
Right, State, you agree?
Judge, I agree, but it's certainly up to closing arguments.
Sure,
as
that's
to the
different.
amount- yes.
We're talking about the evidence. So the evidence, so 14 is granted as far as the evidence itself is admissible. I'm sorry, it's denied as to the evidence. It's granted as to any, the admissibility of the evidence is denied, but it's granted as to any opinion for why the transaction occurred. So denied in part, granted in part. Okay, 15.
You may have already ruled on this in general,
Yeah.
just opining on the phrases.
Unless it's being offered, unless the opinion is part of expert opinion, right?
Yes, Your Honor.
Okay. So I guess it's technically denied, but it only comes in through potentially expert opinion.
Yes, Your Honor.
Okay. Let me just make a note. All right, 16.
I don't think the state's intending to introduce these, but I don't want to speak for them.
Communications between Andrews and Chance.
Judge, we'd agree to 16.
Okay, granted. And I think 17, same, no one's going to opine as to Mr. Chance's reported involvement in the October 7, 2023 shooting of Charles Jones. 18,
It's about a conversation in spaces.
okay. State, what's your response to this one? Are you saying these are, what are these?
Judge, those are relevant, Judge, and we would object. That is the conversation that happens a couple of weeks right before a homicide where he is, and actually not only are the public watching this, but law enforcement is actually watching it and reporting it, and that is when Charles Jones is having a conversation with our victim asking about his foot. The October 7th of 2023 attempted murder that is also tied ballistically to this case. The victim was indeed shot in his foot. So that is relevant, as well as, again, the co-defendants in this case. When that is happening, Sean Gathright is receiving a message from Rashad Murphy where there is dialogue concerned about this happening on X because they have bigger plans. So certainly that is relevant and probative to this homicide.
18 is denied. 19.
I understand Mr. Howard's going to testify, and obviously he could testify,
Judge, I
but
think that was 18.
Yeah, 18 denied. We're moving on to 19.
we're just asking that he not be allowed to opine on what Mr. Chance meant by something Mr. Chance said to him, allegedly.
Okay, David, your response?
Judge, we know that he could not comment on the defendant's state of mind, but certainly he can give his opinion as to their conversation that they were having.
Sure. So it's granted as to, and Mr. Howard opining as to Mr. Chance's state of mind. Okay, 20. Again, This would seek to exclude Mr. Howard giving opinion testimony regarding social media posts allegedly made by Mr. Chance after the murder. State, what's your response?
Hold on 1 second, Judge. Judge, we, again, are not going to ask him what Mr. Chance or the defendant, what he may have meant, but certainly he did testify as to seeing the post and the relevance and the effect on the listener, how it was pertinent to him.
Okay, so it's granted as to opinion testimony. You can't, again, opine as to Mr. Chance's, what it meant when Mr. Chance posted what he did. You can testify to the facts. Okay, and then 21, any allegation, mention, inference, or indication, whether through witness testimony, picture, or attorney statements to the jury regarding Mr. Chance being the mastermind. Is the state going to argue he's the mastermind?
Judge, I do think based on the evidence as well as, Judge, I do believe that is appropriate for closing argument as long as it's based on the evidence that we produced during the trial. As far as eliciting that from a detective
Sure.
or anything of that nature,
No.
we certainly would not be doing
Okay,
that.
because the reason I ask is it did, in the motion, it specifically said attorney statements. So to me, that seems that you would want to prevent the state from even arguing that.
Yes, Judge, but I would agree that I'm more interested in not having the detectives or
Okay.
witnesses.
All right, it's granted as to any witnesses, and it's denied as to the state's closing, assuming they've got evidence to back up their argument.
Sure.
Okay, that's it for Mr. Chance's motion and limine. Okay, are there any other motions? I don't have a pile of anything left.
I think that is it.
Okay, all right, very good. I think we had 59 motions, so we make pretty good progress. Okay, so I think the last thing we need to do is wrap up, and I asked you all, I've taken the motion to sever under advisement, and so my kind of last thing I want to hear from you is now that we at least have an idea as to the universe of evidence, what specific evidence you're going to argue on behalf of your client would be inadmissible if they were tried individually, sufficient to warrant a severance? Does anybody want to kick off?
I will, Judge.
Okay.
Judge, also, and I don't know the court's position on this. As you know, I filed a supplemental memorandum of law as it relates to severance issues. As I told the court that I would like to do last week when we finished with the severance argument, the state in turn responded to that. Is the court going to allow us to argue that as well?
You can.
Okay.
So, but
We can do this now, Judge, what the court asked.
Yeah, it's 2:37 in the afternoon. So if you wish to have further legal argument regarding the severance issue, that's fine. I would like you to first answer my question,
Certainly.
and then I'll give each of you 20 minutes to in total. So it's 2:37. Mr. Gonzalez, you have the floor.
Judge, I did a filing, and essentially the items that I believe would be admissible, not admissible against Mr. Murphy and potentially is admissible by to other defendants. Number one, messages sent by Isaiah Chance to co-defendant Andrews, telling her that he needed to stay low and asked her to remain loyal. That was October 7th, 2023, the same day as the attempted murder of Charles Jones. And I expect Detective Nieder to testify that Mr. Chance and Mr. Gathright were suspects in that murder. I believe
Well,
that.
no, they're not going to testify to that. We've discussed that a couple of times now. No one's going to opine who the suspects are.
And whether or not it's admissible to Mr. Chance, I would suggest that if it is, it's not admissible to Mr. Murphy. Next would be judge on.
Because why?
Because number one, it's outside the scope of the conspiratorial time frame. Number two, it's not relevant as it relates to Mr. Murphy. What Mr. Chance indicated to Miss Andrews about that particular incident. Well, even if it relates to that particular incident, we don't even know if that statement relates to that incident. That would be the state's theory of prosecution. But in any event, it certainly would be impactful. Would be a minimizing word as it relates to what the jury could the road they could go down considering what effect it may have on Mr. Murphy.
Okay.
So
All right, very good.
as it relates to two, that would be the recorded social media video where Mr. Chance is addressing Mr. Jones on X, saying, "Hey, Foolio, your foot okay, cuh? I got bigger fish to fry." Again, this, referring presumably, theory of prosecution, to the attempted murder on October 7th. It would be the same theory, the same reason for inadmissibility, may be admissible to Mr. Chance, and I believe not admissible to Mr. Murphy for the same reasons.
And was that date also October 7th?
That date was June 6th of 2024.
Okay. Okay.
Next, Judge, would be all items, but specifically, and the court's already ruled them to be admissible in general, and that is shell casings that are, and all items for that matter, that are found in Mr. Gathrights' vehicle at the time of the search on June 26, 2024. And again, all of these incidents, Judge, are post-conspiratorial, and ballistic comparison suggests that those casings match the October 7th attempted murder of Charles Jones. May impact Mr. Gathright, may impact Mr. Chance. Again, the same theory as it relates to the spillover, as to the thoughts that a jury may have as to Mr. Murphy's involvement, and I believe that would require severance. Same as it relates to all of the items on June 27th, post-conspiracy.
The physical evidence found.
Yes, items of physical evidence in both circumstances. 26th and 27th as it relates to Gathrights' residence and Gathrights' vehicle. Next, Judge. Chance's Instagram posts that he had to switch it up, coming different, all 2024, love you, brother. Tagged music by Charles Jones.
What is the date of that?
That is November 23rd, 2023, pre-conspiratorial timeframe, and tagging Antonio Tilley and Ghost 187 _. Detective Nieder, I believe, will testify that in his opinion, Chance was upset with ATK because they didn't get a get back for Tilley's murder in October of 2023, and that he had a falling out with ATK and was now associating with 1200. And then Detective Nieder opining that Ghost 187 is Rashad Murphy. Certainly potentially relevant and admissible as it relates to Chance, and under the same theories, in my estimation, and I believe based on the law, inadmissible as to Mr. Murphy. Next, Judge, and the court made some statements. It was not a ruling, but the court made some statements, as I understood it last week, with regard to celebratory statements made by Davion Murphy. Post-conspiratory, I'm coming home, my thirst is quenched, pop a bottle of Don Julio today. And although I don't believe the court made a formal ruling, my argument would be under the same theories and under the same time frame that those statements are post-conspiratorial in terms of the time frame. And although they may be admissible against Mr. Murphy, Davion, they should not be admissible against Mr. Rashad Murphy. Next, Judge, is categorized gang affiliation evidence. These next 1, 2, 3, 4, 5 incidents are, and I don't have any police reports on these things. I don't have any social media posts on any of these things. I don't have any pictures of any of these things. I don't have any videos of any of these things because they appear in Isaiah Chance's gang documentation FIR. So it is an evidence, and to the extent that the state would seek to introduce all of these varying pieces of evidence that I believe may be relevant to Isaiah Chance, number one, to maybe segue into a gang certification or documentation, or as some type of inextricably intertwined evidence. I don't know under what theory, but the only thing I have, and it's very detailed as to its generalities, there are no actual documents that we have been provided because I don't know that they exist. This is the FIR regarding Mr. Chance. For all of those same theories, and the dates are March of 24, July of 23, February of 24, December of 23, March of 24, all in that same time frame, which certainly is all extensively pre-conspiracy. My arguments being the same, they may be relevant and admissible as it relates to Mr. Chance, not admissible in my view as to Mr. Murphy.
Did your supplemental or your amended identify these with specificity, this gang affiliation?
No, Judge,
evidence?
these would be in my filing, a notice of filing. I did an itemized list of evidence admissible against co-defendants, but not the defendant. You asked Judge Firth to orally give it to you.
Yeah.
I just put it in written form.
Okay.
So it'd be a little bit more particularized.
Okay.
Finally, Judge, two more issues. Again, the bully down poster that the court has admitted or determined not to exclude in limine. My position again and that would be inclusive of all the other items. The court, declining to make it, a limited item and allowing it to be introduced, certainly it doesn't change the court's ruling, but it does change in my mind the ramifications as it relates to Mr. Murphy. And therefore, that bully down poster and the other items in Mr. Chance's residence, again, post-conspiracy, June 27th to 24. Although they are seized post-conspiracy, I assume the state's going to say they pertain to pre-conspiracy, not during conspiracy, but pre-conspiracy. And I would suggest again, potentially admissible as it relates to Mr. Chance, and I would tell the court not admissible as it relates to Mr. Murphy. Finally, Judge, there are Cash App records, and also Detective Ramos testified in his deposition about Mr. Chance. You heard about it a little bit earlier that it's Mr. Chance's Cash App is rich on war. He's, he makes money killing people for the gang, and there are several entries to his Cash App. I don't recall whether they specifically reference transactions that the state is going to insinuate may be relevant to this or any other murder or shooting, but the records even in general, with his handle being Mr. Rich on War, again, these are pre-conspiratorial, and additionally, Detective Ramos suggesting he's the mastermind, he handles the gang war, and he is involved in ongoing violent gang activity. Again, I would suggest to the court under all of the same theories as it relates to relevance, as it relates to character, as it relates to pre and post conspiratorial timeframes, might be admissible against Mr. Chance. And I would suggest to the court they, for a number of reasons, not admissible as to Mr. Murphy, and certainly would be extremely, extremely prejudicial.
Okay. All right. Thank you. Okay. Mr. Sonardi, on behalf of Davion Murphy, do you have any additional specific items of evidence that you contend would be inadmissible against Mr. Murphy if he were on trial alone?
In addition to those items that were already
Anything
identified?
other than Mr. Gonzalez just identified?
No, Your Honor, other than any of the social media posts did not involve Mr. Davion Murphy, and none of the rap videos involve Mr. Davion Murphy. We just incorporate all the other items identified as to Rashad Murphy that would not be admissible if Mr. Davion Murphy were tried individually.
Okay, very good. All right, Mr. Wise, on behalf of Mr. Gathright, any additional items, specific items of evidence we've not already discussed?
Sort of, Your Honor. Again, I think Mr. Gathright is a little different in that he's not alleged to have been one of the gang members. So I think 5 of the 6 collateral incidents, I think, would not be admissible against him. Again, for 2 of those, he was a child when they transpired. But I think the only one that would have any relevance to him would be the alleged prior shooting of Charles Jones, and that's only because of the shell casings being found in the car. Otherwise, there's no connection whatsoever to him and the gangs. So I don't think the bulk of the evidence that we've been hearing about, including the communications with Mr. Chance about switching gangs, things like that, I don't see any of that being admissible against Mr. Gathright if he were to be tried separately, because he's not alleged to have been really even an associate of these gangs. The same thing with the rap videos. Other than that, I think it's really the same individual pieces of evidence that Mr. Gonzalez pointed out. Again, I recognize a lot of what he pointed out are things that do relate to Mr. Gathright, being that things are found in the car, but all of these collateral incidents and the discussions of the gangs and whatnot, I don't believe do. The one thing that I don't know if it brought up, but it was subject of one of the motions limited just a moment ago, is the alleged consciousness of guilt of the other Mr. Murphy, which is something that I don't think would be admissible against the other defendants if they were tried separately. And that being the allegation that he went to another jurisdiction and whatnot.
Okay. All right, very good. And okay, finally, as to Mr. Chance, Mr. Petratus, any additional items of evidence that have not previously been discussed?
And I think Mr. Gonzalez spoke about David Murphy's post conspiracy statements. We would also add, we believe, Robert Howard's testimony when it comes specifically to Rashad Murphy, alleged threats he may have made in the history of Robert Howard being convicted of the crime involving a quote-unquote brother of Rashad Murphy. We haven't gotten into this yet, but the drill rap videos, none of which include Mr. Chance, we would argue, and then any historical gang information regarding 1200. Obviously, Mr. Chance has documented ATK, or that's the allegation. We would argue anything about 1200 to be prejudicial.
Okay, great. State, Mrs. Murray, you gonna argue this?
I will try, Your Honor. If I can clarify, does the court wish for me to address the arguments now that were made to each of the defense counsels as it relates to the drill rap videos, or reserve that for when the court has the videos before it?
Yeah, just reserve for the time being on the drill rap videos, just until we know what actually is gonna come in. So,
Yes, Your Honor.
so I guess I just need to know from you, with regard to the identified items of evidence, what's the state's position as far as whether or not those would be admissible against all of these defendants if they were tried individually?
As stated by each of the defense counsels at this point, in its totality, the state's position is that as evidence of principle and as evidence in support of the conspiracy, all of the evidence would be admissible in trial against each of the defendants. Most specifically, because in establishing that one defendant committed this crime, the state would in fact be proving up that each of the co-defendants were in some way related to the offense. If they were gang members, we would still present evidence of that as the co-defendant being a gang member. We would still present each of the articles of evidence that have been listed. I'll go specifically for the court, but the overall position is that the evidence would still be admissible in each of these defendants' cases.
So let's start with the messages sent by Isaiah Chance to the co-defendant Alicia Andrews on or about October 7th of 2023. Would those be admissible against Mr. Davion Murphy, Rashad Murphy, or Sean Gathright if they went to trial individually?
Yes, Your Honor. So we would ask to submit those articles of evidence as evidence of motive in this case, because we have the ballistics evidence that links that earlier shooting to the subsequent homicide of Mr. Jones. We would ask for a limiting instruction in presenting that evidence, but we would certainly ask to admit that evidence in each of their trials.
Okay, I'm not sure. All right, and what about the recorded video where Isaiah Chance responded? I think it was dated June 6th of 2024, where he's responding to, is it Foolio? Who's he responding to? Charles
Yes,
Jones?
Your Honor. They're on Spaces. That's the one where verbally back and forth they are communicating with each other. Mr. Chance is posting on his social media accounts and is going back and forth with Mr. Jones. That, in addition to Sean Gathright and Rashad Murphy then discussing Sean Gathwright's boy going crazy on the internet on his social media accounts and telling him to calm down because they have bigger things to deal with. Absolutely, the state would be seeking to admit the evidence against each and every defendant, including Davion Murphy, given we've charged conspiracy in this case.
Okay. And then obviously the physical evidence that was found at Sean Gathwright's car, at his residence.
Same argument that was previously made and seeking the same ruling from the court.
Okay. What about Isaiah Chance's Instagram post from November 23rd of 23? Why is that? Why would that come in against all the other co-defendants?
So that post is made a month after the earlier attempt on Mr. Jones's life, for the same reason that Mr. Chance and Mr. Gathright were linked to that offense. This is the same offense that we're discussing when Mr. Chance sends the messages to Ms. Andrews in the same month about the earlier attempt on Mr. Jones's life. The law enforcement officers from Jacksonville will talk about how at the same time, it's not just Mr. Jones's life that was attempted at the October 7th date, but in the hours before Mr. Jones's life was taken, Mr. Tilley's life was taken. So the posts from Isaiah Chance then subsequent to that are about how he is transitioning from one gang over to the other because he is upset with how his current gang has represented or come forward in support of the death or homicide that occurred with Antonio Tilley. So when he posts this, he actually tags Ghost 187. At the time of Charles Jones and Antonio Tilley's homicide, Chance was associated with ATK. This is the detective's discussion or describing some of the detective's discussion about how he transitions from ATK to 1200 and how he tags Ghost 187, who we ultimately linked to Rashad Murphy, a 1200 member. So when law enforcement says we saw that he started posting with and he was in music videos with or whatever it was, that there was some relationship between ATK and 1200, this is just evidence of that. The defendant posts this to his social media account. It's actually a video with a
Isaiah
caption.
Chance does.
Yes.
Okay, and then what's your argument regarding the post-conspiracy celebratory post by Davion Murphy? How is that admissible against the other co-defendants?
As it relates to Sean Gathright, it comes from Sean Gathwright's device. The timing of the posts, or they're actually text messages that are immediately sent after the homicide itself. The argument from defense that it's definitely Davion Murphy is not one that the state also takes. Yes, investigators reached out to the recipients of those messages to try and ascertain whether it was Rashad Murphy, Davion Murphy, or Sean Gathright, because it comes from Mr. Gathwright's device. But the messages themselves or the content of the messages are not being offered by the state for their truth. I have no idea if at the time Mr. Murphy or whomever sent the message was going home or had a thirst quenched. Instead, it goes to the identification of the suspects, it goes to the intent in this case, and it goes to knowledge. So we would have sought to, or we would seek to introduce against each of the defendants in a trial these messages that come from Mr. Gathwright's device, but were signed Murph. There is no direct evidence for us to establish whether it was Davion Murphy or Rashad Murphy. The only thing that we have is investigators attempting to follow up with the persons who received the messages.
And that was on Mr. Gathwright's phone?
Correct, Your Honor.
Okay. Okay. Some of this I've already basically ruled on. The gang affiliation evidence as to Isaiah Chance, I'm assuming you would argue that you would seek to introduce that and if these gentlemen were tried individually, correct?
Yes, Your Honor.
The same with the bully down poster, correct?
Yes, Your Honor, same argument.
And the Cash App records for the rental of the Airbnb, right?
Same argument, yes, Your Honor.
And what about Robert Howard's testimony of threats made by Isaiah Chance?
I think Mr. Howard's testimony were threats by Rashad Murphy, if I'm not mistaken. I think that was Mr. Petrides' argument. Is that what you're referring to?
I think that's what he was referring to. Mr. Petrides was arguing.
I just want to make sure we're arguing the right thing. Okay, so yes, Mr. Howard did receive some phone calls or voicemails from Rashad Murphy leading up to the offense itself. Those are relevant to premeditation, motive, and intent in this case, and as it relates to all of the defendants. Mr. Chance is alleged by Robert Howard to have made similar calls, not threatening in any manner, but calls in advance of the offense itself in anticipation of the offense occurring or something occurring in Tampa. And that evidence, again, would be sought to be introduced given all of the defendants acted as a part of a conspiracy.
Okay, thank you. All right, so I'll start with you, Mr. Gonzalez. What is your response to the state's contention that Davion Murphy's celebratory post-homicide of Mr. Jones would be admissible against your client, and that it's not hearsay because they're not trying to prove the truth of the matter, they're trying to prove identity?
Identity as to
who the perpetrators were?
Well, Judge, I can tell you that as I remember it, the two messages that went out went to two separate people. Although law enforcement was not able to talk to one of the two, they did speak to one of the two. And Detective Ramos says it was Davion Murphy. I spoke to that person, and that person indicated to me that it was Davion Murphy that sent her that post or sent her that message. I don't know details on that. I am referring to Detective Ramos's testimony, and in that light, and the fact that, as I believe it, Mr. Davion Murphy has been identified, and I think Detective Ramos will testify as such, at least to one of those two posts, that in and of itself, it would not be relevant and it would not be admissible as to Rashad Murphy. And simply to identify, okay, if it's going to identify anybody, it's going to identify Davion Murphy because that's what the person on the other end of it told Detective Ramos. So that would be my position as to its relevance as it relates to Mr. Rashad Murphy.
Okay, so I'm not so sure, as I indicated, I'm not sure about the celebratory post-homicide, and I'm not sure about the message being sent by Isaiah Chance to Alicia Andrews after the October 7, 2023. I'm not sure. And I know I don't want to roll the dice in a death penalty case, so state, you just really need to think about this, because I'm not sure about those two. They would be admissible against all of the defendants. I don't know.
Yes, Your Honor.
So,
Judge, I know that you said the Alicia Andrew and message to from Charles, I'm sorry, Isaiah Chance. What was the second one? The post by Davey and
Yep.
Murphy afterwards?
Mhm.
Okay.
as I
And
sit
Your Honor,
here,
I just want to confirm, I understand that the motion from the defense are referred to as celebratory posts, but in confirming with the defense, Mr. Gonzalez is actually referencing the text messages from Mr. Gathrigh's device. 2 sets of text messages, not posts, because there are posts.
Again, my illiteracy when it comes to.
let me see them, please.
I've seen them, Judge. And Judge, I might take this one step further, is I believe that when Detective Ramos spoke to one of these ladies, she in fact knew Davion Murphy, but did not know Rashad Murphy, as I remember it. And I could be wrong. I don't think I am, but I think that inquiry was made of Detective Ramos in deposition.
Okay. As I indicated, I'm not sure. And I'm not really inclined to roll the dice in a death penalty case. Okay. So state, it seems to me you're gonna have to pick.
And you're referring to the text messages and the postings as well, or no?
No, it's just the post that was found on Sean Gathrigh's phone post homicide. And then the message from Isaiah Chance to Alicia Andrews on or about October 7th, telling her to stay low and be loyal. Okay.
Is the court making a ruling on the celebratory post that we're discussing that from Gathrigh's phone?
Yes, I'm saying that I'm not sure that those would come in against, well, I basically am. I'm telling the state they're gonna have to kind of pick. So I don't, as I sit here right now, unless something changes my mind, I'm not sure that those 2 items of evidence would come in against all of the defendants. So the first one would come in potentially against Isaiah Chance regarding his conversation with Ms. Andrews. And the item found on Sean Gathrigh's phone would conceivably come in against him. I'm not sure they would come in against the other co-defendants if they were tried individually. And even though it's not a brutal problem, does it become a other problem, meaning it somehow significantly impacts the defenses of the other co-defendants? And I don't know, but I'm being extremely cautious. Okay. So basically what I'm telling the state is if they really want this evidence to come in, then I would be inclined to sever. If not, then I wouldn't be. Okay. So.
And just can I ask one follow-up in respect or in regards to that? If you are inclined to sever, would it be picking more than one jury at the same time or separate trials?
Well, that's a good question. Probably more than one jury. I gotta think about it. So it's kind of an open question mark at this point, but I'm not sure. Okay. So state, you want some time to think about it and let me know?
Yes.
Okay. All right. So how much time do you need to respond? You want to file something?
Yes.
Okay.
Judge, can we have till, we need to talk about it and
Sure.
have till next week?
Okay, sure. That's fine. To next Friday?
Yes, Judge.
All right. So you guys have until next Friday, the 13th, just to file something. If there's additional case law or additional argument you want me to consider, but you know my concerns.
Yes, Judge.
Okay. Okay. All right. I think that's it for today. We covered everything.
I want to put something on the record, Judge.
Sure.
Judge, I had previously asked the court whether or not I could argue the supplemental memorandum as it relates to severance. And that was mainly, I argued extensively last week with regard to the grounds for severance, and the court has my motion that's whatever, 35 pages long. And that should be an amended. I hope the court has an amended.
Yes,
Okay.
yes, an amended, yes.
So Judge, essentially, I just want to say that at the conclusion of the severance hearing, the court didn't issue a ruling, still hasn't, obviously, taken it under advisement, but indicated a concern or a question to me as to whether or not pre and post conspiratorial evidence may be admissible against all defendants if the court determines that it's inextricably intertwined. And also asking, is there some case law or is there a position in the law as it relates to co-conspirator statements versus co-conspirator evidence? And I'm not going to argue the supplemental filing. I think it speaks for itself.
Okay.
It identifies case law. I will tell you, in my opinion, there's not much Florida state court law on it because I think it's a settled issue. There is some federal court law that I've cited to the court, and I know the state differs from me, and she has made that plainly clear in her response. But to the extent that that an act or a declaration should be separated and should be considered under different theories, I think is not the case.
Okay.
And so I would suggest to the court that for as long as I think we all should remember, the law clearly establishes that acts or statements of a co-conspirator are only admissible against another co-defendant if those acts or statements are made within furtherance of the underlying conspiracy. And I think that all evidence attributable to a co-defendant, but not attributable to Mr. Murphy, that especially falls outside that conspiratorial range. Because every one of the things we talked about that the court has considered, we are still in this post and pre, and we're also outside of that temporal range, and also discussing an act or a statement. And I think the memorandum sets out, in my mind, what is required, what the case law says, and how it establishes that the spillover prejudice that will exist, and despite any instruction from the court, by the way, despite any limiting instruction, the damage would be so significant that I don't believe a jury could compartmentalize in that particular circumstance. And as it relates to the state's response, Judge, I'm just going to say, generally, the crux of this issue is that the state, when it applies a co-conspirator rule to only hearsay, the rule has existed for decades before the hearsay rule was created, and it was never limited to statements. The hearsay rule merely codifies the existing law as it applies to hearsay. And other acts committed by the defendant may be admissible in conspiracy cases to show the evolution of the conspiracy. The key is that those should be acts by the defendant. It has never been applied that I'm aware of to a non-participating co-defendant. And that's just my response to the state's response, if you will. Thank you, Judge.
Okay, thank you. And the clerk just asked me, Rashad Murphy's fourth motion in limine, did we discuss that? I feel like we did, but maybe.
We did, Judge.
We did, Your Honor.
Hold on, I'm looking for it. The fifth, I have the third, where's the fourth?
It was a short motion concerning opinion evidence, and I cited the Bentley case.
Yeah. Yes. Yeah, there's the second the defendant, Rashad Murphy's second motion in limine. Yes.
A last minute action at the bottom, but we had already addressed the fourth one to the opinion.
Okay. All I see is Rashad Murphy's fourth motion in limine. I thought have I not ruled on that
Yeah,
yet?
but that was a ruling on number, that was the same one. It was the opinion one, I thought, but then that was number 11. Is it
Yeah.
number 11?
Yes.
Which is like the same motion, but.
Yeah. I think, yes, I think that's just a typo from the state,
All right.
in the state's master list.
Okay,
Yeah.
Well, then I got it then.
Yeah,
I
yeah.
wasn't sure about that.
Okay, yeah, that's just a typo. So, and then I did, and if I didn't officially state it, Isaiah Chance's motion to adopt and conform applicable motions of all co-defendants, that's granted.
Okay, thank you.
Okay,
I got them all.
okay. All right, well, very good. I will take a look again at the updated case law that you've provided me, as well as the state's response, and then I will await clarification from the state regarding the items of evidence that I have a concern about, and then I will issue a ruling. Okay? Okay, I think we're done for today.
Okay, guys. Okay, so I got a couple things. Y'all heard at the end that they were talking about the severance, and they were going to give a state an opportunity in order to decide if they really needed those text messages in badly. You remember I went over earlier and showed y'all the motion where that was denied. So I guess I kind of had that one out of order regarding that. The next thing, I was reading the trial backwards, guys. The way they have it for the trial start date when you go into the file, it's kind of backwards. Long story short, the jury trial is supposed to begin on April the 8th, 2026. I know somebody in the chat, I can't remember who asked, but they were saying, is it going to start on Monday? Yes, it is going to start next. It's going to start on the 8th. I guess that's going to be jury selection. Let me say that much. April 8th is a Wednesday. So I don't know if they do jury selection Monday and Tuesday, and then they start the actual case on the 8th. And it's supposed to go through May sometime. That's what they say. I don't know. I'm not sure if it's going to be May or not, if that's going to be. But we will, of course, have more information when that comes up. So what I would like to do real quickly, I got 2 documents that I want to show you guys for decisions that were made in the case, just so y'all can have the most up-to-date information. You know, sharing is caring. So let's get this up here so y'all can see this. So this is in regards to Sean Gaffright. As you can see on my thing, I'm gonna try to blow it up a little bit better for y'all. And basically what this is the judge completely denied a motion to suppress. This motion to suppress was the defense wanted that entire search warrant of his car to be suppressed. The judge did deny it, and that means all the key evidence stays in. Remember, when Sean Gaffright got pulled over in that Forerunner, you know, for the traffic stop, they searched the vehicle, and then they went and searched his residence. In his vehicle, he had firearms, he had ammunition, he had shell casings. Guys, he had shell casings from a redrum that wasn't this redrum. So he had shell casings from another redrum in his car. I don't know what this goofy was doing, but he had all the stuff in his car. And if you guys remember from the Alicia Andrews case, we actually seen Sean go to his grandma's house and change out all of the stuff from the vehicle that he was originally in and switch it over and put it in that Forerunner, right? I don't know why he didn't take the stuff out. I don't know why he was riding around with it, but that's what he was doing. So the defense, their argument was basically they were trying to say that it was the stop was illegal and that the vehicle search was illegal, and everything afterwards is like fruit of of a poisonous tree. So if you wasn't supposed to stop him and they could have got out that part was illegal, then everything else that they found after the stop would have to be thrown out. So we listened to the testimonies, and if you guys did not see it, I'll attach it in the playlist in the description. The detectives were already surveilling this Toyota. They said that the vehicle was speeding at the time and had that dark illegal tint. And then they said that's what triggered the stop. And then they said once the vehicle was stopped, Detective Griffin said he smelled that marijuana, right? That medication. He had the defendant, of course, step out. We talking about Sean Gaffright in this point, and Sean Gaffright is the light-skinned one that was on there inside the vehicle. So he said he conducted a search. Inside the vehicle, they found marijuana residue in a jar and a grinder, suspected mushrooms, a firearm, additional firearm accessories, shell casings, live ammunition, cell phones, and later this led to a search warrant for the residence. Now, the defense said the officer did not properly measure the speed. They're saying like he couldn't do the estimation with his eyes. Now, I don't know, some of these cops we talk about, they can tell how fast you're going by looking, but the defense is saying no, they couldn't measure his speed with just an eye test. So they saying the stop was based on the estimation not reliable, and that the search was done without probable cause. So that's their way of, they were trying to get it thrown out. And they saying the marijuana claim was weak, very unclear. So what the judge really focused on, the judge looked at, was the stop valid? Was the search valid? If not, does the good faith exception apply? And so the judge basically said the officers had reasonable suspicion. Speeding plus dark tint equals valid basis. So regardless if they want to argue if he was able to measure it with his eyes, although the speed was not with the radar, it was based off of our officer's observation. So, you know, and of course with the smell of marijuana. So basically what she did is denied it. So with her denying their motion to suppress the evidence from the vehicle, the home warrant is invalid because it came from that legal stop. So that made the home search valid. So judge just said nope. And this loan document, I think it's like 85 pages or something. And I had to I was trying to skim over and get most of it out of here. But the vehicle search is not being suppressed. The warrant was approved by a judge. It was based on the evidence lawfully obtained, and it was in good faith. So that is in regards to that portion for you guys, so y'all are aware of that. And then I wanted to show y'all something else, and I really want to kind of get your opinion on this, and this would be the last thing I'll cover. I won't do it in a different I won't do it in a different stream. I want to talk about this with you guys now. Let me see if I'm sharing the right screen. Okay. So guys, I wanted to ask, because I'm going to touch on Alicia Andrews' case really, really, really quickly. It shouldn't take us long to get through this document. It's only like 15 pages. Now, what I would like to know as we are reading through this document, let me see if I can get it bigger. Let me see if I can get these tabs out of here. Sometimes I know how to do them, sometimes I don't. Sometimes I feel like a nut. Okay, here we go. Let me try sharing it again. Okay, so hey Mary. Okay, so I want to go over this. This was filed by the defense on February 26, 2026. Now, you guys, if you don't know, Alicia Andrews' defense team, remember they wanted to disqualify the judge, which is Judge Cisco, who is also going to be covering the other 4 defendants that are left. She did get disqualified, and Alicia does have a new judge. So here we go. This is the introduction of her motion. So she won a judgment of acquittal not to withstand the verdict and or a motion for a new trial. So right here is the introduction. It's saying the 2nd District Court of Appeal. This is like good things going on here. I mean, I think personally, having found Ms. Andrews' motion to disqualify the trial judge legally sufficient, and Judge Michelle Cisco being disqualified from these proceedings, allows this court to reconsider each of the previous judges' factual and legal rulings. I say this because there were a lot of things that Judge Cisco kept out of Alicia Andrews' trial. I also say this because she was supposed to disqualify herself, and she did not disqualify herself. And the defense of Alicia Andrews, what they did is they appealed it, and the appeals court even agreed with them. So that's like a check mark, right? That, okay, we are claiming that the judge did not make good legal findings, good legal judgment. She didn't even disqualify herself. But the appeals court said that she should have disqualified herself. So that may mean she may have made some bad judgment calls in her thing. Okay. So right here. Okay. So let's finish reading. The rulings include, but are not limited to, rulings on motions in limine. We got motions for judgment of acquittal, motions for special jury instructions, and all the rulings are on the evidentiary objections made during the trial. Now, the prior rulings may be reconsidered and vacated or amended by the court. Ms. Andrews requests that the court reconsiders her motions for judgment of acquittal, vacate the previous denial of those motions, and grant Ms. Andrews a motion for judgment for acquittal. So, in the alternative, Ms. Andrews requests a new trial because the only remedy for the remaining rulings would be to impanel a new jury so that the case may be tried with the correct pretrial and trial rulings. Under the circumstances, Ms. Andrews is due a new trial. At the very least, this court or the appealing court must grant Ms. Andrews a new trial because the disqualified judge committed reversible, it should be probably irreversible, error by denying Ms. Andrews legally sufficient disqualification motion. So the error was not harmless because the judge made several consequential decisions that would have altered the outcome of the trial. I agree with that. We've seen that in real time happening. The defense couldn't get anything in. This is going to be the same thing that we kind of probably hear with the false case, where they can't get nothing in. So thus a new trial must be granted. For the sake of the judicial economy and the efficiency to all parties, this court should grant Ms. Andrews a new trial rather than passing the issue to the appellate court, who will surely grant Ms. Andrews the request of relief. Remember, they say in the appellate court. That's important because remember, they just want to appeal where the judge said that she wasn't disqualifying herself. Let me see. So they kind of talk about the facts on June 23rd in regards to the victim, Charles Foolio being killed, being unalive. Her and these 4 men that we currently watching today. It says a motion in limine. So prior to the start of trial, the defense moved a limine to preclude the state from introducing evidence of year-long Jacksonville gang wars, rap music videos, and various uncharged crimes to the state that the state sought to introduce. Judge Cisco denied the defense motion and allowed the state to introduce this evidence. The reason why this is a problem, because Alicia Andrews is not in none of these videos. She is not in a gang. She's not a gang affiliate. So why was that stuff able to be presented in court? And remember, she's the only person in this whole situation that had her case separated. So let me see. So the defense also requested that Ms. Andrews be allowed to present evidence about the nature of her abusive relationship with co-defendant Isaiah Chance. The defense proffered that such evidence was relevant to Ms. Andrews' state of mind, which is always relevant in a first-degree redrum case. where the state has to prove intent and premeditation. Although the defense made it clear that it was not introducing this evidence to support an affirmative defense to murder, Judge Sisko and the state erroneously and repeatedly framed the defense request as an attempt to use domestic violence as a vehicle for duress defense. And y'all remember we went through this when we were in trial, right? We went through this where they tried to get other people to come in and kind of testify, and the judge denied it, saying that the only way that any domestic violence was going to be able to come in is through Alicia. So that's another reason why Alicia had to take the stand, because she was trying to get those photos of saying that, hey, Chance was, beating up on me or whatever the case may be. And look, I had to do what he was saying. So that's another thing that the defense wants to get in. So the stories that were presented at trial. Okay, so at the trial, the state attempted to prove that Ms. Andrews conspired with her co-defendants to unalive Charles Jones. Why? Because Mr. Jones, an alleged gang member, was engaged in an alleged gang war with Ms. Andrews' co-defendants, who are allegedly rival gang members or gang associates. So they do put allegedly. Over the years, many children, teenagers, and young adults were killed as a result of this gang war. Okay. So there it is. Like, she wasn't involved in any Jacksonville gang war, nothing like that. But they're trying to say she was joined in the conspiracy with co-defendant, of course, Isaiah Chance. So the defense denied the state's allegations, arguing that Ms. Andrews never conspired with her co-defendants to kill Mr. Jones. Ms. Andrews did not even know two of her co-defendants. Remember, she didn't know these Murphy boys. The only person she knew was Chance and Sean. The only co-defendants Ms. Andrews had a relationship and communication was with her boyfriend, Mr. Chance. When Ms. Andrews discovered that Mr. Chance was leaving Jacksonville to go to Tampa, Andrews wanted to go with him. Ms. Andrews knew nothing about a murder plot when she decided to make the trip. She merely believed she was going out of town to spend time with Mr. Chance. Mr. Chance and the other co-defendants arrived in Tampa Bay. They left her in an Airbnb for hours, and they went to go look for Mr. Jones. At first, the group of boys were unsuccessful, but then they continued their efforts, and they eventually were able to locate and gun down Mr. Jones. Now, Ms. Andrews, wait a minute, Mr. Jones, wait a minute. Ms. Andrews provided no identifiable assistance. So they saying she didn't do anything like far as that portion. Did not know about the conspiracy. Let me see. Preview to trial issues. So y'all know about all the evidentiary wars that we had in there. It says Ms. Andrews didn't have any motive for wanting Mr. Jones dead. Okay. Defense sought to establish that nature, exclusion of notwithstanding. Judge Sisko ruling that the domestic violence could only come in through Ms. Andrews. That's why she took the stand, y'all. Because she was trying to bring in that domestic violence. The defense attempted to call defense witnesses who would speak to her personal knowledge of her domestic violence. Okay. Y'all remember those years old text messages where she was texting with her friend and she said Mr. Jones was an ugly ass bitch and Mr. Jones needed to die? The defense objected to the omission of that text message. The defense argued that the text messages occurred long before the time period, right? Those was a long time ago. I remember it. So the charge conference, this is another big thing. So during the charge conference, when they're deciding what they're going to put on the verdict form for the jury and how that's going to look and things like that, Judge Sisko and the parties addressed the lesser included offense of manslaughter. Judge Sisko asked the defense whether it was seeking manslaughter instruction under both the intentional act or the culpable negligence theories. The defense requested that the jury only be instructed on an intentional act theory. Judge Cisco then asked the state if they wanted to include the culpable negligence theory with the manslaughter instruction, and the state responded yes. So Judge Cisco included the culpable negligence theory in the manslaughter instruction over the defense objection. So the defense requested the following special jury instructions be included in the principal theory instruction. So then they go into what they wanted to have included. The state argued that the standard jury instruction was sufficient, and the defense argued that Ms. Andrews was entitled to these instructions because, one, the special instruction was supported by the evidence, and two, the standard instruction did not adequately cover the theory of the defense. So the next thing is this motion to disqualify the trial judge. Remember, that was filed on October the 31st, 2026, that morning, right after the charge conference. Remember, we saw that paperwork hit, and the defense filed that motion to disqualify. That motion was based on the various instances. And I think that's half the problem, guys, because I think that when they did this motion to disqualify, if Judge Cisco would have really took it up under real consideration and disqualify herself like she was legally supposed to, then it wouldn't even got to the jury. Like, there would not have been a verdict. You know, they would have to assign a new judge, you know, do all of that background, that stuff again. So that right there, I think, is the biggest problem, because she should have disqualified herself. I don't think that they are even supposed to have a verdict. So the case was handed to the jury on October the 31st, 2026. After deliberating, the jury found Ms. Andrews guilty of the lesser included offense of manslaughter and not guilty of the conspiracy to commit first degree redrum. So they didn't, y'all know that she was just the jury. Okay, so what it says, the jury verdict indicates that the state failed to prove that Ms. Andrews acted with any criminal intent, that the homicide occurred as is required to convict up under the principal theory. Now, they say the verdict is questionable because there is absolutely no evidence of a manslaughter introduced in trial. Was it maybe? Yeah, that is that's a typo. Go on, Mary, get it. Yeah, it was October 31st, 2025. They got October 31st, 2026 everywhere. Yeah, they got a typo. So after the trial, the court set Ms. Andrews' sentencing hearing on December the 8th, 2025. On November 11, 2025, Ms. Andrews filed a timely motion for the judgment of acquittal, notwithstanding the verdict, or a motion for a new trial. On December the 4th, Ms. Andrews filed her with a prohibition with the Second District Court of Appeals. So I say all of this to say, and this is just the laws and stuff in regards to this. I think that Judge Cisco really messed up this case. So I do think she's guilty, because I don't think nobody could be that blind like to this stuff, even if they're, you know, we at an Airbnb and I see your homeboys come, like, yeah. And then we taking an Uber home. Like, nah. That's too much for me. So I think that when they're talking about the errors, I think they're actually right. But, you know, my whole thing here, and y'all know that this has always been my thing, is that I don't mind you being guilty. And if you're guilty, you're guilty. But my thing is, you got to be guilty the right way. So, and with the right charges and the right thing. So I mean, I guess it's not their fault that this Judge Cisco, maybe that's why she being very, very careful in regards to her rulings. And she like telling the state, like, hey, if y'all want to bring in them text messages, then we got to have two different juries. And I don't want something to be too prejudicial for one defendant versus to the other defendant. So it seemed like she really, she really staying on, she trying to cross her T's and dot her I's is what I would like to say in this regard. So I just wanted to kind of give y'all that information that I have for Alicia Andrews. And the sad part is that if any of the jurors knew what went on with Alicia Andrews' case, or if you read this document, it almost sounds like they are throwing her, like Alicia's attorneys. Like I almost think like if you read this, you could say that she basically saying they did it. I just didn't have nothing to do with it. So does that mean like, because it almost, and I know you want to put out allegedly, but you saying that you didn't go there, you didn't know that this was happening, these things is happening. So you actually are conceding that these things happen, or am I thinking about it wrong? Because it seemed like to me in this document, when they're covering her, and of course that's their client, so they're doing whatever they need to do. But it sounds like when you're saying, hey, look, I went there to go kick it with my boyfriend. They may have done these things, but I had nothing to do with it. That's not like you're saying that they did it. Yeah, because they said there's no evidence of manslaughter, Martina, and they didn't even argue nothing. Like none of that came into the trial. So I really think that she's going to get a new one. I think she'll get a new trial. I don't think they're going to acquit her. So that they can forget about that. That I don't think. So that's just the update. And like I said, I'll put that Alicia Andrews, and she's due back into court. I think I've seen it. Let me see if I still got it up. I know we got a court hearing tomorrow, but that's for the guys. That's a status hearing. So we got that tomorrow. Alicia Andrews, the state has until April the 3rd, 2026 to file a response. So I'll keep looking the eye out on that. The defense will then have another opportunity to respond 7 days later on April the 10th, 2026. And her next hearing date, let me see what day. Her next hearing date is going to be May the 11th. So we should see some stuff drop down early April for her. April the 3rd, the state has to respond, and then the defense has to April the 7th to respond, and then they're back in court on May the 11th. Yeah, they do have a different judge right now. The new judge, her name is, what is her name? They have a new judge, and that's why they asking the new judge, hey, this new judge, their rulings may be completely different. Like different stuff may be able to come in and, to that nature. So, and since we know that Judge Cisco she was disqualified from the case because the Florida appeal said, hey, yeah, well, some of these rulings, you were biased, like we saw all of this stuff. So they definitely got a new judge. It's just now the judge is reviewing over if she should get a new trial or not. I know that they're not going to acquit her. I cannot imagine them acquitting her and saying, here go the slap on the wrist, go home with your life. I can't see that. I can see the state trying to go back after this, or maybe offering her some type of plea deal. Maybe. Okay, so that's that. So if we're going to be in court tomorrow, if they're going to have a live feed, I would definitely bring it to you guys. So make sure you hit your like and subscribe. For those that are going to Hawaii, y'all see the room is set up. We'll be over there at 5 o'clock when that hearing starts. So I'll see you guys over there then. Shout out to the chat. Thanks to all the new subs. We got a lot of new members today. So I appreciate you all. You know, nothing is without the chat. And if it's your first time coming and hanging out with us, make sure you come hang with us again. Claire, I think that she was going to try to use domestic violence as part of her defense in some shape, way, form, or fashion. They just wouldn't let it happen. They let it happen, but it was just so minute that you had to believe everything that she was saying, and she didn't have nobody to back it up. Okay. So we got about an hour and 15 minutes before Hawaii starts for a hearing. I have no clue what this hearing is about. It was not scheduled until today. So we'll see what this hearing is about and kind of go from there. Once again, I want to thank you all, and I'll put on our outro song, and I will see you in a minute.
Take it to
Oh, that's the intro song. That's the intro song. We won't do the intro song. We'll do the outro song.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mods on patrol, chat is showing out. This little YouTube corner's what community's about. Therapists you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taking to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Fowler brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach's chosen, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taking to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white claws, way managing volunteers like she runs the whole land. Cynthia brings inside, would take sharp and steady. Donna keeps it real, 911 and always ready till he burns the fat queen. Receipts on tap, Easy's new, but she blends right into the pack. Tennessee, hard live, try support her with pride. Melly shows up a family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Barker loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care smile. Mods and shadows, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever take it to trial. Couldn't ask for more.